Kindly.
Yes. Yes.
My lord, matter for memo for being spoken to. There is a memo for being spoken to, my lord. There's a mistake in the order. My prayer with respect to my disconnection of the electricity connection. My lord, in this I had challenged the DC's order where my license for stone quarry was suspended, my lord.
So you want to get it listed?
Please, my lord.
We'll list it once you remove the officer.
No, this is not a fresh matter. It is
Old matter. After.
No, not being spoken to. You file a review petition.
But the matter pertaining to my lord tender, Lord, the Honorable Learned Single Judge has set aside the tender process, my lord. I am for the respondent in the writ appeal. Lord, this Honorable Court has granted interim order. Lord, by virtue of interim order, my lord, the appellant is re-notifying the tender. If it is re-notified, my lord, the entire, Lord, my right will be affected and third party interest will be created. It's a pending matter, my lord. May I request, my lord, any date convenient to my lord?
Not that urgent. It is not that urgent.
Yes,
It can be waited after 10 days.
please, my lord. Any date, my lord, after.
After 10 days, give any.
Please.
Your Lordship,
Yes.
one contempt matter, against the contempt of court matter against the BBP commissioner. This court passed a direction in respect to Malatali Lake. It's a complex about 72 acres. To fence it and also not to give for any cultural or recreation as for any political or individuals. In spite of that, the BBP commissioner is permitting that tomorrow the festival is there in the same place. Because earlier, last year, this court specifically passed on Shivratri matter. No such thing should be permitted. Contrary to the Karnataka Tank Conservation Development Act, the BBP commissioner is filed a contempt which is pending. So kindly take it up tomorrow, Lordship, so that the BBMP commissioner know, because there are 72 acres of lake which has to be fenced.
Within a week, we will list.
Because we filed on 24th February, it's still not listed.
It will within a week. we will
Because
list.
day after tomorrow is the festival. 8th, that is the reason.
Festival can
Please,
go.
oblige.
Yes.
Pending matter, my lord, petitioner challenging the endorsement rejecting the mines license, my lords. Respondent reject the license, my lords. So kindly have it on.
Fresh matter.
Fresh.
No, my lords, pending matters.
Pending matter will be listed. Why don't give number? Will
Please,
list.
my lords.
Give your memo. It will be listed within 10-15 days. See that.
My
Depending-
lordship,
Depending upon the year and the
And
last listing.
word.
my lords, we have filed the matter on 21st August, but as of it, the matter has been not listed, my lord. The petitioner was legally mining,
You must not have removed the objections.
my lordship. Sorry?
Objections are removed.
No, my lordship, this is a fresh matter. We have filed on 21st August. They have not
Objections are-
listed it yet. The petitioner was legally mining.
Objections are removed.
Sorry?
Office objections are removed.
No, my lordship. We were not
Clear
given.
the
First, clear the office objection.
The matter was posted for auto listing, my lords. So we didn't get the chance to clear the office objections, my lord.
Make a note in the memo itself, permitted to clear the office.
Yes. Yes, Mr.
Lord, contempt petition, my lord, pending matter, my lord. The notice was issued on 22nd, 2023, my lord. Directing the government to file a compliance affidavit or objection, my lord. Till today, my lord, they are not filed.
Within
Complainant is senior citizen, my lord.
after
retired-
2 weeks. After 2 weeks.
The retirement benefits, my lord, has been withheld by the
On
government.
fresh education matter, I have complied and removed all the office objections, but it has not been listed. Can it be taken
Within
up
5 days,
tomorrow?
it will be listed. Within 5 days.
Please.
Yes.
Fifth day.
My lord, I'm moving this memo, my lord, regarding mutation entries, my lord, in favor of my,
We can wait.
my lord, this is AC has passed order in our favor. Deputy Commissioner has passed
After
order.
50,
It
after
will
2
be
weeks.
changed back to
After
the,
2 weeks, yes.
my
Your
lord.
Honor, the employees are sought for regularization as they were contractual employees in the University of Mysore. The University of Mysore has challenged this in this present appeal, and they are on the verge of superannuation. And UGC prescribes regularization up to 62 years.
After 4 weeks, yes. Yes.
Lord, matter pertaining to mines, my lord. Respondent has cancelled the license of the petitioner, my lord. Renewal license of the petitioner, my lord. For stone quarry.
After 2 weeks. After 2 weeks.
Much obliged. my lord.
Yes.
Let's may I mention for adjournment, my lords, serial number 67. my
Wait,
lords.
Mr.
Is a,
Let the
is a
memo
fresh matter,
complete.
my lord. Objections and all cleared, my lord. Is for admission and seeking for interim stay, my lord.
What is the matter?
Is the matter pertaining to the gratuity, my lord.
Gratuity
Yes, my lord.
after 2 weeks.
But there is a direction from the authority to that with 7 days time has been given, otherwise that.
Let the board get streamlined. Every day we don't know how many matters are being
Yes,
listed.
my lord.
We'll just control the listing of the number of the matters. And then any number of matter can be listed once it is controlled. Yes.
My lordship, it is a commercial appeal, my lordship, pending cases, seeking permission for withdrawal amount, deposited amount from the trial.
Withdrawal of amount
Yes, withdrawal of deposited amount,
after 10 days.
please.
Yes, anything?
Serial number 67, my lords,
67.
for appellant, my lords, seeking short accommodation in the matter. We have informed the other side, my lords.
You are Vishnu Hegde.
No, my lords, I'm for the appellant, Manu K.
Yes. So
For the appellant seeking short accommodation in the matter, my
2
lords.
weeks.
Obliged, my lords.
Inform the other side.
We have informed.
Serial number 70, my lord, the connected matter 70. I'm representing appellant Mr. A. Sampath, my lord.
70.
70, please, my lord. I'm
Yes.
representing Mr. A. Sampath appellant. I informed the opposite, my lord. I just pressed for 2 weeks time, my lord. This is finally,
2 weeks.
please.
Service
My
of
lord,
copies to the other side.
I will inform, my lord. I will.
My lord,
Okay.
serial number 54, praise time, my lord. For petitioner, appearing for petitioner.
Praying for time.
Yes, my lord.
54.
Ah, yes, ma'am.
Mineral matter, 54.
Serial number.
Why?
Praise time, sir.
For what purpose? Not that contentious matter. Anyway, when do you want?
After 2 weeks.
2 weeks.
Serial number 51, my lord. Kindly take up by next week.
Serial number
51,
51. Time. You want time?
2 weeks, my lord.
2 weeks.
It has to be tagged with 210.
Yes.
My lord,
Yes,
serial number 63.1.
Madam,
Serial number
Madam,
63, my lords. Serial number 63, my lords. I'm appearing for 63.1.
63.
Appellant
63.
63.1, my lords. A week's time, my lords. Please. Appearing for
For
Venkatesh
final
Somareddy.
disposal. 2017 matter.
It's a week's time.
Let us see what it is, then we'll grant.
And permission. Still number 1. So.
So 1 to
Submission matters.
1 to 12,
May I make one request?
Appellant, my lord.
1 to 11, 3 weeks.
May I make one request, my lords? Serial number 3, my lords, in the.
Serial number 3, my lords,
Three, my lords. In this
translation has to be filed, my lords.
Lords, in this matter, the government is intending to build an 100-bedded cancer hospital in a district called Shimoga, my lords, a land belonging to the government. Before the learned single judge, the direction was for the appellants to approach the civil court if they have any agitation with their rights as such.
And it comes for hearing, we'll consider.
A date could be fixed is only I'm requesting, my lords. A date could be fixed after a week or 10 days.
16 all cases.
I understand,
Again,
Lords.
Can you are making
Please,
such submission?
Please. Just wanted to make.
We don't appreciate asking any
Please.
of the advocates asking for a date.
Please.
Please.
In the same matter,
We have complied with them.
but it's in this,
Yes,
In serial number 6, my lord,
6,
we have complied with them.
complied with.
Yes.
Who is for the other side? Raghavendra.
Raghavendra C.
So let it be posted on
Office to verify.
Monday,
Yes, my lord.
Monday,
but it's in serial number 3.
Monday in the hearing board. Yes,
That's serial number 5.
Serial number 3, my lords.
3.
In serial number 3, my lords, additional advocate general had given an undertaking not to, that they'll not put up construction that may be extended, my lords.
That undertaking will continue.
Please, my lords.
My lords, it's serial number 5, my lords.
5.
Only office objections, the court fee has to be paid. That has been paid yesterday. Notice be issued to the respondents, a contempt matter, my lords.
All right, notice. The officer,
Yeah,
objection.
Copies
is
have
no-
been served, my lords. Court fee has been paid.
Notice.
Please.
Yes,
GA takes notice to a pro forma respondent, notice to A1 and A2.
Please, my lord.
My lord, serial number 4, my lord.
Fetch.
The court fee has to be paid, my lord. Course of the day, I'll do it. I'll pay the court fee, my lord. Notice maybe should.
Pay first, then we will notice.
Next week, my lord.
next.
Serial number 2, my lords.
The office objection is regarding service of copy to the pro forma respondent, my lord. During the course of the day, I'll serve the copy, my lord. Notice.
Serve it.
My request for
Sir,
issuance.
no condition. Don't ask all those things. Don't complain.
Once you do it, it will be listed after.
Pending complaints, no notice.
Serial number 1 for the complainant, all the office objections have been complied. It's posted for non-compliance again.
Serial to counsel for the complainant submit that
Fine.
complaints is made office to verify.
It will be listed within 5 days.
Number 12 for 9 tribe to MV Charity. Bill number 12.
Your Lordship, I pray for 1 week time, Your Lordship.
Granted, 1 week. 13.
Number 13.
Lords, I appear for the petitioner, my lords. Lords, I am appearing through VC, my lords.
Fair for impleading applicant, my lords.
For
Lords.
respondent, lord.
Lords,
This
we
petition-
request,
Impleading applicant, my lords.
lords, we request for a week's time, my lords.
This petition is not maintainable, my lord, because it is covered by the judgment of this honor.
Lords,
And they are seeking review of the judgment.
we have not been heard in the matter, my lords. There is, kindly have a look at the order, my lords, dated 27/6/2022 of this honorable court.
The last may kindly peruse the prayer.
Land, same land.
Same.
So page 282. Page 282 is the order.
Yes,
What does it say?
282. And this judgment of this honorable court, my lord, has been affirmed by the apex court also. They are what ups?
Now, what is this, Mr.? What is this petition?
This is about, my lord, even where preliminary notification under section 4 of Karnataka.
Lords, it's a writ petition in the manner of review, my lords, because the all other writ petitions or
Supreme Court
writ
order.
petitioners were not heard at the time of disposing a single writ petition. Lord. Lords, the lordship may kindly peruse order dated
But then
20.
Supreme Court has dismissed the SLP.
Yes,
Yes, my lords, but all other writ petitions, my lords, were not listed and they were not heard, my lords. Kindly, my lords, order sheet on 27/6/2022, my lords.
No, this is review application in the very petition. No,
No.
independent. How can you file independent petition?
Lords, I am impleading applicant, my lords. Lords, Sukhdev Singh versus my lords, State of
review in the
Punjab, my lords.
form of writ petition.
Honorable Supreme Court, my lords, in the year 1962, my lords, if the parties to the writ petitions are not heard, they can file another writ petition seeking review of the order, my lords. Lords, kindly, my lords, 27/6/2022, my lords. Order sheet, my lords.
Firstly, decision of coordinate bench.
Sorry, my apologies, my lords.
How can we review it?
Lords, my lords,
Number 2, it is confirmed by the Supreme Court.
lords, kindly.
May I-
Order dated 27/6/2022, my lords.
Where is that?
Lords, in the order sheet, my lords.
27?
6/2022, my lords.
Yes. Which are the other petitions?
My lords.
Some other petitions are pending.
Yes, my lords, that were not listed and heard, my lords, at that point of time. I am for the impleading applicant in this writ petition, my lords.
Let it be listed together.
My lords, I have filed an impleading application also, my lords. I am for the impleading applicant for the reason that, my lords, the notification that has been allowed, my lords, is affecting my rights of mining also. Because at the time when they given the mining lease, it was not within the forest area. My impleading application may be allowed and I may be permitted to come on record, my lords.
We don't think that you can get any relief. from this.
Now the settled position is that, my lord, by the virtue of this order, even if there is section 4 notification, notifying that particular preliminary notification, notifying that particular area as forest to be constituted as forest, as a reserve forest or whatever. That has to be construed as forest. No non-forest activities will be allowed. within that.
My apologies, my lords, my apologies, my lords. My lords, I am for the writ petitioner. The matter, my apologies, my lords. The matter requires to be heard at lordships and my lords. The order stated 27/6/2022 directed that the matter is to be because there were an order of the coordinate bench is in my favor. My lords, only one of the matter was taken to the Supreme Court where the Supreme Court made certain observations. It is in the background of that when the state appeared before the Honorable Supreme Court, the Supreme Court said that all the matters will have to be reconsidered at your lordship's hands. Lord, that's the reason why we are again before your lordships, my lords. And in view of Shivdev Singh's case, since we were not heard in the matter, my lords, we had filed this petition. So your lordships may fix a date for hearing, my lords. I'll be before your lordships.
Ask the office to put up this.
So office hasn't listed other matters. Other matters are not listed.
Yeah, but sir,
The earlier
before
order,
that,
some
when-
numbers are mentioned.
Yes, my lords.
Get it listed,
along
get
with-
it listed. After 2 weeks,
Lordships, grateful, my lords.
on that day we'll consider.
Kindly.
Lordships.
Grateful, my lords.
Lord, the very maintainability of this petition in the nature of review.
We are aware, but then there is an order
Lords,
of coordination.
Shivdev Singh's case and Pola Singh's case squarely covers this issue, which was cited, my lords, before the coordinate bench on 27/6/22. Lordships, grateful.
Grateful.
18-4.
14 awaiting.
14.
My lord, serial number 14, I appear for the appellant in this matter, my lord.
Awaiting service.
My lord, lordship will kindly permit me to, my lord, issue hand summons meanwhile, my lord, because appellant is a senior citizen, my lord, therefore there's grave urgency in the matter, my lord.
Hand summons is permitted.
Grateful, my lord.
The returnable date shall be
2 weeks
19th
time.
of March.
Grateful.
Number 15.
The complaint, my lord. Lord, after filing the petition, my lord, the complaint died on 26/4/2023. My lord, I filed the LR application. Item number 3, my lord, IA number 2/23. Kindly be allowed and permitted the
2/20.
LR.
LR. To bring the LR.
2/23, my lord, LR application.
LR application is granted.
Come on record as a digital response.
23 allowed. LRs are permitted to come on record as legal representatives of the complainant.
Item number 4 and 5 is not present, my lord.
Learned counsel for the complainant not pressing IA 1/23. Submission placed on record, IA 1/23 dismissed as not present. You can do the impleading, impleading and the needful. Office note, there will 3, 4, 5 shall be deleted. Memo dated 17/6/23 dismissed as not present.
Much.
Number 16. Dev Prasad Shetty.
Appear for the appellant's counsel.
May I
Yes,
seek some
yes.
accommodation to file objections to the IA for stay, my lord. The
It is.
order, my lord, of the learned single judge is in January 2023. They have now filed the IA for stay, my lords. May kindly grant me some time, lord. I'll file my objections.
I served that application on my learned friend about 15 days back, my lord.
Yes, I'm not.
Again,
disputing.
seeking time is
A week's time, lords, may kindly grant.
24, there is some office objection is there.
Yes, my lord, that's what
that
they have
that
filed.
will attend to it, my lord. His signature is necessary, but your lordship may.
Submit that the defects in IA 1/24 will be cured. Now what? That is.
In the companion matter, my lord, actually, in the first matter, there was an order with regard to translation, which applies to companion matter also. But it appears the office has not noted it.
16.1 dismiss agite, please check it. 15.1, is it dismissed?
But it was dismissed, not their appeal was dismissed because they were not compliance. They have filed some
That
application.
has
writ
been
appeal was
recalled.
withdrawn.
After recalling, order is also passed.
Still one more objection is there.
That objection, actually in the first matter, with regard to that objection, order was passed. That was to be followed in the second matter. It appears office has not noted that.
Translation lot of Kannada documents to English.
You want
In-
time?
Not 1 week, not to comply with, to file objections to the IF for stay, not that they have filed.
Lush, may kindly have it on Monday or Tuesday, my lord. There is some urgency. The difficulty is this, my lord. After taking benefit of this order, right, left, they are dismissing the removing the members from the society so as to make the petition infructuous.
You are for original petition.
Yes, my lord.
But
That is, therefore we are
For
seeking.
original.
But I am also a petitioner. Well, my writ petition is allowed. They also filed a writ petition. Their writ petition was dismissed.
They filed for what relief?
But I had challenged not the order passed not by the registrar, not virtually nullifying not the election not to the post of president of the society.
There are two
But
groups, my lord.
now-
Both of us are claiming.
1 second, you challenge the appointment of administrator.
Yes, no, what not the authority did was, not he cancelled the election and pass an order not to not direct that, let the administrator be appointed. But election cannot be set aside not by the registrar. He has no such power. So learned single judge says you have no power to interfere with the election process. Power to appoint an administrator is different issue altogether. So learned single judge say in effect you have nullified the election itself, which is not permissible.
Elections were held.
Election was held, my lord, and I was not second petitioner, my lord, in the my writ petition was not elected as a president.
It was a general election to the body or of the.
But it's the executive, not members not will vote. There are not about 100 odd members.
It is general election to the managing committee.
Managing committee.
Managing
Yes.
committee.
There are two factions. We claim that we are the elected persons. Learned single judge wears the robes of district registrar. He says, it's all right. I consider that they are to be elected. You can go to civil court. It is something extraordinary.
20th March.
Please, very well, great.
Court of
Upon administration, ask the legislative. Will be listed.
Please, along with two, four, seven.
If it is a special bench, then let it be separate for the time.
That kindly say
That
my
this may be
rejoinder.
disposed of so far as
Appeals will be listing after passing order on administrative side.
please.
Appeal is listed
will be
so long ago, my lord. It's
Will do
not
that.
listing.
Will do, yes.
post along with that. No. Submission ಅಷ್ಟೇ ಹಾಕೊಳ್ಳಿ. Writ appeal 2476 of 2015 is pending. Hence, 4 weeks are.
For the petitioner, my lords. This is, well, this is a matter where the learned single judge has
Against
directed-
the main order, my lord, we have filed writ appeal. Writ appeal 288 of 23.
You have filed.
We have filed the appeal that
When it is going to come up,
it should,
not listed.
it's not listed.
They filed it with multiple objections. They did not choose to comply with the objections over a year.
No, it
matter
is
did not
complied,
come
now
up
it
for
is numbered as 288 of
My lord,
23.
great respect, this is solely with the object I would submit to prolong the proceedings before this court.
Let us see what is the direction.
The learned single judge clearly directed that there should be a refund of the excess interest paid as well as return of my securities. Look, the short issue is only this. My lords, we kindly appreciate the short issue is only this. Certain excess interest is paid to the institution. Court held that interest has to be refunded. In addition, my lord, they have my securities. They are not releasing securities.
The time of retupping.
My lord, even if the whole of the amount is not refunded by them, the
Formally,
securities
Mr.
can't be
Counsel, if
continued to
the
be held.
appeal is filed, they must have.
But my lord, there is more than 4.5 crores is held up. My securities are held up. My lords may give an urgent date in the matter. If both are to be heard together, the contempt and the appeal may be put up together.
After 10 days, appeal may be listed. And this may be also listed along with the.
Much obliged.
Yes.
19 we have complied, my lord.
Complied.
Appearing for document number 2, filing complaints complied with.
My lord, he was retired, my lord, in the year 2008. They have not settled the pensionary benefits, my lord, till today.
Now is complied with.
Yes, my lord.
No,
We
my
have
lord.
considered the
If the
request.
objection, my lord, have it next week. If there is any. Put a copy.
The direction is to take, my lord, the appropriate decision.
Benefit is paid or not paid?
As per the audit report, the amount is due from the complainant himself, from the complainant himself, the employee.
I'll file my counter, my lord.
And to that effect, the deputy commissioner
Ask for
passed an
reply,
order,
my lord.
which is produced at annexure R1 to the complaints affidavit.
Where is your decision, but?
Last may kindly produce para 3.
No, where is your decision?
Decision annexure R1, page number, my lord, translation is at 7.
17/11/22.
My lord, the direction, my lord.
Direction, yes.
Page 11, my lord, para 8.
Direction 19/7/2022, please.
In compliance of the direction. The reference of.
Direction issued by this honorable court, my lord, page 11, my lord, para 8.
You challenge this.
Let him challenge this order.
My lord, see, have it next week. I'll file a counter, my lord, your lordship can
No
hear.
question of counter, sir. You challenge that endorsement, that's all.
My lord, this is the seventh seventh matter, my lord, in the litigation, my lord. In all the cases, my lord, you are succeeded before this honorable court, my lord.
In this contempt application, the directions issued by learned single judge as per in order dated 19th July 22 are sought to be complied with. Paragraph, the directions read as under extracting paragraph 8 from the order and quote paragraph 8 from page 11. Used to when the proceedings come up for consideration, learned government pleader, learned government advocate, Mr. Mahendra stated that the direction to take appropriate decision is complied with regarding claim of the superannuation benefit of the petitioner. He produced the decision. Communication dated 17/11/22 reflecting the decision of the competent authority. It is recorded in the decision that while the petitioner is not entitled to an amount, on the contrary, certain amount is recoverable from the petitioner.
The amount, the pensionary.
Following is stated, then court, as per the above, court, I'm dictating. Court into court, as per the audit report, amount of rupees 8,81,190 is to be collected from Mr. Uttegowada, retired Group D employee, and rupees 4,04,136 withholding amount to be paid to the retired employee, and the balance of rupees 4,76,923 is due. Full stop. Since the decision is taken as per the directions of law and a single judge, the order can be said to be complied with. No further adjudication survives in this contempt proceedings. Paragraph. At this stage, learned advocate, Mr. So and so stated that the applicant may choose to challenge the aforesaid decision on merits, such liberty is reserved for the applicant. However, this court does not express any opinion on such course of action and the merits thereof. The present contempt proceedings are closed.
Class 4 employee, my lord, is suffering, my lord.
To
not
challenge
settled.
it, right or wrong decision, we are not concerned. Once there is a decision, the directions are
The
complete.
7th proceedings, my lord, against him, my lord. In all proceedings, he was succeeded before this honorable court, my lord. In all proceedings, including suspension and also inquiry and all, my lord.
So you challenge it, Mr.
On personal revenge, my lord, they are passing this order, my lord.
We are in,
Settle the benefit.
we are in contempt jurisdiction, Mr. Counsel.
Great.
We can't enlarge the things, yes.
System number 20. Sanjeev BL.
Petitioner, my lord. Some inconvenience today, my lord. Short accommodation, may I request.
In this, there are earlier occasion, 2 orders passed by this court for the state government to take a decision in the matter, my lord. Request for further 4 weeks to take a decision in the matter.
Lords, I am appearing for the Lords, contempt petition of the Lords.
This is regarding
I-
allotment.
I seriously oppose, my Lords, the kind of
What
indulgence.
has happened is, my lord, acquisition has been upheld. The property, owner of the property is Muda, that is Mysore Development Authority. Now, my lords, the erstwhile owner and the revenue site owner are before your lordships, my lords. Claiming right over the property in question. Now, the government has to take a decision as to what.
Notwithstanding the judgment dated 22.
No, what are
Yes.
that's what the main judgment says, my lords, the acquisition has been upheld. In the review petition, the court says notwithstanding upholding the acquisition, it is for the Muda to decide whether they want to give the land, to allot the land to the review petitioners therein.
This judgment is was
In the review petition.
review petition.
Lords,
It's an
this was in the
observation.
review petition and this is confirmed even by the Supreme Court.
1 second, by single
What's
judge.
Division bench, my lords.
So then how can this order can be passed?
That's the point.
That is the. The division bench judgment,
How the other coordinate bench can say that notwithstanding that order?
that according to us, my lords,
Same bench.
The same bench. That is why matter requires consideration. Learned AG is not seeking
This is, we are in contempt.
contempt and writ petition also.
because
I am just asking to understand, nothing more.
Sorry.
I understand, man, where your lordships are, I'm in full conformity with your
Nothing
lordships.
is suggested, I just trying to understand you, yes.
So the,
In writ petition challenging the acquisition came to be.
But learned advocate general wants time.
Yes.
Lords, may I make
because
this
my lord, your
request?
lordship may
If Lords
kindly see,
prefer to,
the
Lords, I,
reason why I'm taking time is on the earlier 2 occasions, a submission was made saying that the government is going to take a decision in the matter with regard to
mute ಮಾಡ್ಬಿಟ್ಟಿದಾರ.
to point out where the contempt,
Taking decision,
please, my lord.
government.
Government, my lords.
Lords, may I make this request, Lords, if your Lords is to permit me to?
We'll do that, we'll do that,
Resolve the conflict if any.
we'll do that, we'll do that. Only thing, kindly have it after 4 weeks, my lords.
Lords, I seriously oppose, my lords. This is a contempt jurisdiction where the
Then I'll
commissioner
argue
has
on
taken an
contempt.
undertaking, my
There's no
lords.
contempt at all, if he wants to argue.
I'm more than willing to argue the matter. If the Advocate General wants me to argue the matter, I have no problems to argue the matter.
Mr. Counsel,
Lords, just at the instance of,
we are giving time.
Lords may grant about 2 weeks' time, my lords, because this time has been granted from the past or 4 months.
General submission not ಮಾಡ್ಕೊಳ್ಳಿ. Government is considering the taking decision, taking 4 weeks time.
We'll do that, my lords.
But in the writ petition, there is an interim order that has to be extended.
21 ಅಲ್ಲಿ
Interim order.
ಮಾಡ್ರಿ.
Not, I'm sorry, my lord, I couldn't, not extension of interim order. It is till today.
ಮಾಡಾಯ್ತಿರಿ.
Grateful, grateful.
ಯಾಕೆ ಆರ್ಭಟಿ ಅವ್ರಿಗೆ ಈಗ
I'm
ಸ್ವಲ್ಪ ಈ ತರ
sorry,
ಆಗ್ತೀರಿ ನೀವು?
just anxious.
ಯಾವ
Great,
question?
great.
15th April. This is number 21.
For the complainant, my lord. This matter pertains to appointment of the complainant for compassionate appointment, my lords, for the death of her mother. An endorsement was issued, my lords, which was challenged before the KAT, Karnataka Administrative Tribunal.
Now, we have issued an endorsement, my lord, considering the entitlement of the complainant.
This honorable court, my lord, the division bench of this honorable court. Kindly see the order of this honorable court, my lords, for which have been before this honorable court. This honorable court specifically said, my lords, sub-rule 2 and 3 of compassionate appointment rules will not apply, my lords, will not preclude the government from giving her employment. And now they've taken shelter under the very same rules. Grant of an endorsement, my lords, on the same verbatim, same endorsement which was set aside by the division bench of this honorable court, my lords, itself is contempt. Kindly see, my lords, annexure B, which was challenged before the Karnataka Administrative Tribunal, where they said, my lords, I would take your lordships to English translation, which is at page 25, where they said, last para, my lords, under sub-rule 2 and sub-rule 3 of Karnataka Civil Service Compassionate Appointment Rules 1996, your application seeking for appointment on compassionate grounds cannot be considered. This, my lords, was challenged before the Karnataka Administrative Tribunal. The order is at annexure C, where the endorsement was set aside. That was challenged, my lords, by filing a petition at annexure A, page 13. All these aspects are considered.
What is amended rule?
Amended rule came into effect from Lord 9/4/2000.
So what was that rule? What was the amendment?
The amendment is to the effect that it includes Lord married daughter and.
This aspect, my lords,
Criteria was changed.
the divorced daughter is not entitled for compassionate appointment on the death of her mother, was the issue in this matter. This aspect has been considered by the division bench of this honorable court at page 17, paragraph 9, my lords. This very aspect has been considered, and this honorable court, looking into the definition of the family and also considering a division order, my lords, of the Supreme Court,
Today, my lord had disposed of one matter, my lord, 2 months. Time may be granted to consider the representation.
Again, my lord, it is not. 1 year has been.
Next week I'll
1 year has been already lost.
I'll file my objections.
PL Sanjeev under text to appear for the accused.
15 March. Number 23, to Gautam Dev C. Ullal.
This matter, my lord, I
Here
appear for
also
the, yes, ma'am.
Complied with?
You complied, my lord. The complainant, my lord, has been withdrawn from the charge sheet. May I, just filing a memo, my lord, the compliance report.
Withdrawn from the charge sheet?
Maybe closed.
Complaint, sir.
Complaint.
It's accepted.
Mhm.
Closed.
So closed.
Yes.
The PL Sanjeev files complaints report, complaints memo. Gautam Ullal has not repudiated. Memo placed on record, contempt closed.
Obliged.
Office to delete the name of B.S. Srinivas in the card list.
Number 24,
For the complainants council, the direction was to carry out the necessary changes in the record of rights. By mistake, it was shown as acquired.
2 weeks time may be granted, my lord.
Either A1 and A2,
2 weeks time.
and at GSC 2 weeks time. To comply the order.
Till number 25,
Lord, in this matter, I'm filing a memo, my lord, we have complied with the order. Direction is to conduct body and duress.
Direction was to conduct and duress proceedings. Saying, my lord, they complied it. Let them serve a copy.
Learned Government Peters,
Look at
Mr. Mahendra states that the directions under contempt are complied with. In that regard, he produces the, what is it?
RTC and mutation register extract,
Memo
memo along with the document.
showing the,
Affecting the revenue.
memo along with the documents in showing the compliance. The memo is filed by the Tehsildar. It is stated that the respondent have conducted Podi and Durasti as per the directions. And the name of the complainant has been mutated in the revenue records. The memo is taken on record. Since the directions are complied with, the contempt proceedings are closed and disposed of.
number 26, Mr. N.S. Butt.
In this case, they have not complied. I have filed my detailed objection. Matter has to be heard, man. Matter has to
We
be
have
heard.
filed complaints affidavit. We have complied.
Not,
order.
I have filed my detailed reply yesterday. They have not complied with. There is a specific direction,
Enhancement of salary,
enhancement with arrears of
arrears of salary.
arrears of salary. A
Not
specific,
done.
they have not complied. I have filed my detailed statement of objection. Matter has to be heard. There, kindly see the direction passed by this honorable High Court at para 10 and 11.
This matter.
Now, on the
got raised.
basis of a clarification given by the finance department, in fact, finance department has nothing to do. For the last 11 years, they are working, my lord. Up to 2017, 50,000, 55,000, 65,000 has been paid abruptly on 1/4/2017.
Not, the initially salary was.
They have been
56.
discharged, under the order of the court, they are being continued.
Yes,
Please.
50 plus 5,000, 10% increment every year. The base, it is not on the cumulative salary. It is on the basic fix initially, my lord, as per the conditions of the appointment order.
Government is giving 10% on 50,000. They want increment on the increment.
Then you file appeal then.
They have not preferred appeal. They have now interpreted the order passed by the court.
But,
If that is the grievance, my lord,
Whether the directions are justified or not, we can't go into it.
please, ma'am.
what I advised to them also. In fact, I have advised.
Pardon?
In fact, I have advised the department to file an appeal also.
Yes.
Lord, in terms of serial number 2. Lord,
So it is enhancement by 10%.
Please.
10%. In terms of serial number 2, we have been paying. Their contention is, Lord, on the cumulative.
No, not a cumulative, my lord. From 2013, they are paying 55,000, 60.
Say today it is 5,000.
Please, ma'am.
Next year 5,500.
Please, ma'am, please.
Then next year 5,000, 10% on 5,500.
Please, ma'am. That's.
Yes, to-
No.
That's.
The contention of the state is that, Lord, as per the appointment order, at serial number 2.
What does this notification provide?
Notification annexure A I have produced, ma'am, in contempt petition.
Annexure A?
Please, ma'am.
It is not available.
Sorry. Annexure. I have produced.
Statement of objection. Counter.
Page number 37, Lord.
37.
37, annexure.
Condition number
Annexure
2.
C, my lord.
And notification dated 31st May 2011. Page number 37 of the contempt petition.
Page number?
Page number 37. The clause 2, my lord. During the term of appointment, the court managers will be paid a monthly pay 50,000 to be increased by 10% every year. Simple, my lord. There is no complication as.
The government is giving only 10% on 50,000.
Now again, they rely upon the old circular issued by the finance department, which has been rejected by the learned single judge. Annexure R7.
Monthly salary of 50% increased by 10% every year. Monthly salary remains the same is the contention.
You have to, what council says is entirely correct. So seek instructions, I will get it and enforced. It is very good.
Yes, order is very clear.
Order in this notification is
Notification also.
50,000 by, to be increased by 10% every.
Please.
Your notification itself speaks it.
Yes.
Then,
But their interpretation is that, Lord, the monthly salary remains the same. It is constant. And every year 10% will be.
Every year, yearly is on par with the increments.
Up to 2017, they have paid it.
It is
Thereafter, abruptly on 1/4, they have stopped it. I have filed a representation.
The contention is, Lord, it's not on the last run salary.
The directions, the direction.
Yeah, last may
Not to
kindly
be-
grant us 4 weeks time, Lord. by
Will
the
grant
judge.
the direction of learned single judge sought to be complied with in this contempt proceedings is that the respondent number 1, 2, 3 shall honor the terms and conditions of the appointment of the applicant, appointment order of the applicant dated 31/5/2011, and the monthly pay of rupees 50,000 shall be increased by 10% every year. The paragraph, the applicants are the court managers. Their appointment and the conditions of appointment are reflected in order dated 31/5/11, which figures at annexure A in the, on the record of the contempt, on the record, full stop. It clearly provides that 10% increase is to be given every year in the salary, which was originally to be the fixed salary of 50,000, to be counted with 10% increase every year for further 10% increase.
But
Full stop. The reading of the notification of appointment dated 13/1, 13/5/11 is unequivocal. Full stop. The contention which coming forth from the side of respondents raised by learned government pleader, the 10% increase is to be applied only on the original amount of 50,000 could hardly be countenanced. Full stop.
So when DA is announced, the DA will be calculated on the existing basic, not on the original basic.
Yes.
That's the principle here.
We have, the court was constrained to make above observations in view of the resistance shown by the government in compliance of the order by interpreting the clause in the appointment order as above. Full stop. With the above observations, further 4 weeks' time is granted.
Much.
The respondent, within which time the direction shall be complied with.
Much.
And the arrears, if any, shall be paid. Put upon
18/4.
when 15th April.
Much.
15th April.
Obliged.
Number 27.
In this matter, I appear for the complaint. What of the respondent, what of the have not, accused have not complied the order. What of the, may I take note to the page number 13?
Inquiry was to be completed.
Yes, not.
No,
That inquiry, not they have conducted, not they have not placed any record before.
What was that inquiry? Department inquiry?
No, Lord, here was, Lord, he had, the complainant had claimed for the compensation for the land acquired.
Yes.
Lord, our contention, Lord, that the learned single judge recorded a finding that there are certain claims filed by the others. And Lord had directed us to complete the inquiry. Lord, in the meanwhile, Lord, one of the claimants who had purchased property of that particular property has filed a writ petition. And this honorable court is entertaining, and there's an order of stay for the disbursement of the compensation. And that is what.
May I take note page number 13, notes what I have claimed before the learned single judge. Notes I have specifically asked 40 into, not 60 into 40 developed site.
Who filed the writ petition?
Lord,
Lord, some third parties, not, they were nothing to do with this property and.
Go there and implead yourself in that writ petition.
Lord, that apart, not. Even Lord, kindly see the Lord specific direction issued by this honorable court. Lord, may I take note of the page number 17? Page number 17 for a moment, Lord. Lord, the same Lord claim they have made before the learned single judge. Lord, the learned single judge specifically stated that according to them only they have initiated inquiry through special task force. They inquired into the matter and Lord, they come to the conclusion that Lord, this complainant is the owner of the property. Lord, then that is so, my lords. They don't want to Lord, place that record before this honorable court. Lord, somehow they wanted to Lord, get rid of this by issuing endorsement. That Lord, the endorsement itself, Lord, not fully complied, Lord, as per the order. May I take note of that endorsement? Endorsement also, Lord, it shows that Lord, I am the owner, I am the khatedar, and Lord, my land is acquired. Lord, these persons were nothing to do with that land. Lord, these persons, not in fact, not at the time of acquisition itself. Sorry, Lord.
You are for Bangalore Development Authority.
Bangalore Development Authority.
At least you take some decision.
Lord, we have taken a decision now since in
Where is
view.
that?
Sir, R1, Lord, I have said that there is a stay, hence I cannot give it to you. That's all we have stated.
R1.
R1, Lord, page 5 is the Kannada version, page 6, the translated version.
Page number, para.
And Lord, I have no objection, Lord, kindly connect that writ petition along with Lord, this contempt. Lord, I have no objection because not.
Let us understand. Where is R1?
Lord, the annexure R1, Lord, at.
Yes,
page-
R1, page 5.
Page.
Translation is page 7.
Yes. Senior last. Lord, Lordship may kindly see, Lord, the the page 7, Lord, the second paragraph, upon examining. Upon examining, there is totally an extent of 9 acres, 6 kuntas in survey number 26 of Gedlalli village, KR-Puram, Hubli, Bangalore, East Taluk, out of which an extent of 5 acres, 33 kuntas was finally notified for formation of Arthavati layout on so and so date. IF Dominic.
You go in this writ petition.
My lords,
1633.
yes, my lords, I will come. Kindly, my lords, I may request, my lords, kindly, my lord, that writ petition may be, my lord, placed along with this contempt. So that, my lords, the fact is this, my lord.
But contempt doesn't survive once there is a stay order.
My lords,
In respect of.
because, my lord, those parties, my lords, who have approached the, my lord, the learned single judge, does not have any, my lord, the right in the property.
All that
According-
we will keep this contempt pending, but you go and implead yourself.
Yes, my lords, yes, yes.
Learned advocate Mr. So and so stated that in view of the fact that this court has in writ petition number 1633 of 23 has granted stay order in respect of the payment of compensation, the applicant herein would seek impleadment in the said proceedings. And for that necessary steps shall be taken within 2 weeks. Full stop. It goes without saying that. Doesn't say that.
Yes.
So this is to be listed after 4 weeks.
For the complaint, my lord.
At present, no further steps or order is needed in the present proceeding in view of the above development.
My lords, I appear for the accused number 3, my lords.
I appeal for the complaint. my
Appear
lord.
for the accused number 3.
I appeal for the complaint, my lord. This honorable court has given the, permitted me to file the representation before the accused number 2 and 3.
My lords, only after BDA hands over the property
For Commissioner,
for BBMP, my lords.
PDA.
I'm
Yes, sir.
appearing for the BDA, man. That's 2 weeks time is,
Lords, already 4 weeks has been given, my lord. It is,
my lord. Difficulty is, it's a vast area of land, my lords.
Lord, it's-
There's some difficulty in identifying the parks and CA sites.
what
2 weeks
about
time.
400 crores, my lord, as on today?
Place it on record.
Identifying the land.
The parks and CA sites, my lord, it's a huge, vast area of land, the layout.
Lord,
There's some difficulty in particularly identifying those, the parks and CA sites.
Lord, the worth of that property as on today is 350 crores, my lord. They've allowed it into the hands of the land grabbers who have already put up constructions on the parks and CS sites, my lord. Despite there is a relinquishment deed in favor of the BDA.
You are, why, how
By
could
the
you make such a
society.
statement being a BDA? You are unable to trace out?
My
All
sincere-
your agents will able to trace everything.
Sincere apologies, my lords. 2 weeks time may be granted.
It's based on the relinquishment deed, what has been executed to the BDA. BDA was supposed to take possession of the parks and civic community sites. And
So we are supposed to take possession of the encroached area.
Please, my lord.
in the
Please,
park.
Please, my lord.
please,
And then my brother is rightly saying, how can you
My
say
lords,
that you are not identifying?
Because, my lords, the layout plan is the society's layout plan. My lords, if 2 weeks time is granted, my lord, I'll place it.
I
on-
will grant, but not on this pretext.
Please.
2 weeks.
lords, it's a 350 crore worth property, my lord. The PDA is neglecting.
Because PIL.
PIL, my lord. It was PIL, my lord.
2 weeks time, finally, my lord. Order of place it on.
Learned counsel, Mr.
Chinmay Kuran, lord.
For,
I'm appearing for B Vachan.
for which number 2?
Please, Commissioner of the.
Commissioner of Bangalore Development Authority.
Please, sir.
Raise for time, for 2 weeks, stating that steps will be taken
Please.
within such time
Please.
to comply with the directions of learned single judge brought under the contempt.
Division bench, my lord. This court, my lord.
Division bench of this court
Please.
brought under the contempt. So after 2 weeks, something concrete will need.
25-3.
Oh, please.
Number 29. Mr. Raja Ramesh.
One report has been given, my lord.
39, 20.
For the respondent through my, while the compliance affidavit ratification. Compliance affidavit, some picture.
One report has been given, my lord. In fact, my lord, before the concerned authorities, my representation was that, my lord, they have to conduct the spot inspection in regarding my residential houses, my lord.
due to the construction of Hemavati Reservoir project, my residential houses have been collapsed. Due to such, my lord, they have to conduct the residential houses, spot inspection in regarding residential houses.
My lord,
Niravari Nigma.
yes,
Yes, sir.
A2 has filed its compliance affidavit, my lord. In that, my lord, they obtained the report from the technical committee, my lord. You will also be kindly turn annexure R1, my lord, page number 7. In that, the technical committee has given the report stating that that Nelluli village is not affected by seepage, my lord.
You have to submit a translated copy, sir.
This is so in view of the same, my lord, since that particular village is not affected by the seepage, question of rehabilitation or and at the time of inspection also the particular villagers, all the villages were also present, my lord. So since that area is not affected by seepage, question of payment of compensation or rehabilitation does not arise.
The last may kindly peruse para 3 of the affidavit filed by them, not because in which it is clearly stated 12-member subcommittee, joint committee and technical committee inspected the spot. A joint survey was conducted on 9/7/2000. Page number 2 of the affidavit filed by Nirav.
Affidavit filed by? Para 3, my lord.
Para 3.
Manjunatha.
Yes, not Manjunatha, my lord. Sankarai Gowda.
So paragraph 30.
Yes. Shall I read my? Yesterday it has been reported. The affidavit dated Lord 5/3/2024.
And produce the photographs also at next round.
Photographs is speaking against the technical report. Water goes to the doorsteps of the village.
Para 3.
My lord, in there.
Photona ಹೇಳುತ್ತೆ. ಊರೊಳಗಡೆಗೆ ನೀರು ನುಗ್ಗುತ್ತೆ.
And thereafter, my lords, other infrastructure has been provided, my lords.
Summer it is okay, rainy season
No,
and
no,
other
rainy-
things.
During July only, this technical committee has inspected the spot, my lords, and thereafter obtained all the 12 departments. They obtained the report from all the 12 departments. Then they come to the conclusion that there is not a seepage affected area. And thereafter, my lords, all infrastructure facilities has been given, such as drainage and roads. And thereafter, my lords, from the central government, my lords, from the Pradhan Mantri Sadak Yojana, which is at annexure part 3, my lords, 322 lakhs has been spent by the central government to improve the village with regard to the providing of all infrastructures, my lords. So in view of the same, my lords,
32 your lordship, let's see the last. Not from some bit of seepage affected. And we develop providing basic facilities. Last, this one, second line. All these factors. That this village does not come under the limit of seepage of
Committee can take. What is that higher committee? Why you are writing last line? Are you not sure about this committee? Page 32. Just go to page 32. You say taking all the factors into consideration, it is considered that this village does not come under the limits of seepage affected village, and this village can be developed by providing basic facility. Then last line, further the higher committee can conduct site inspection and decide. What is it? You are changing your stand. Not sure. Even if you take a stand, you take it courageously. Why this shaky stand?
Totality of the report is not conclusive, sir.
Yes.
At Godamel, Deepa
Yes. No, then thereafter, my lords, all infrastructures has been provided by these, not only state, my lord, then subsequent thereafter, the central government has also taken up the, under the Pradhan Mantri Gram Sadak Yojana.
In the writ proceedings, you filed your counter?
No, my lord.
Did not.
That is only written mandamus, my lords, and we are not
Wait, wait,
afford to
wait, wait.
file our objection also.
Now they are
The
saying that,
written mandamus.
now they are saying that, my lord, they are going to give the facilities. But since 1990s, my lord, the houses have been collapsing due to construction of reservoir project. The houses have already been collapsed, some houses.
My lords, one submission,
There is
now
no-
also there.
On record, no, there is nothing.
But they have to conduct the spot inspection regarding the houses, my lord. How much it has, how many houses have been collapsed? That they have to measure.
Then that exercise we can undertake in this proceeding. That is the order.
drone photograph says your village is beautiful.
Yes, even now also they are
Exactly.
putting up house construction.
Village is
in the
beautiful,
same
my
area.
lord, but houses are collapsing. It is in Sakleshpur Taluk. Village is very beautiful. Just like Kashmir.
You say Kashmir village is just like Karnataka village. Why do you go where? You file
Can make it.
better things, take a better stand, even if you are right. You seem to be shaky in your stand.
My lords, we have given all the infrastructure facilities, my lords, and
You file the things, further things.
yes,
Other affidavit, clarify all those things.
yes, yes,
Remove all the ambiguities, sir.
yes. 4 weeks time I will have it.
Learned advocate, Mr.
KS Bhimaya.
Bhimaiya.
Yes, ma'am.
Yes, Bhimaiya.
From the Neeravari Nigam.
Raise that, the respondent number. Your
Two, my lords.
two will file further
Removing the
affidavit
ambiguity.
stating, making the specific awareness.
Yes, ma'am. And in fact, we'll make a further inspection and we'll file a report.
Taking the specific evidence to evince clear stand of the respondent
Much, much.
in relation to the contempt alleged. So you do whatever, give the proper details, be specific.
Yes.
Much.
Date good. 4 weeks could.
Four.
Not, I'm filing objections. I'm appearing for the accused number 1. I'm filing objections. Complainant.
3-0.
My lord, it's ready.
Compliance ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
Compliance.
Objections, ma'am. I'm for
Objections.
accused number 1. I'm filing objections, ma'am.
Received the copy of objections just now, my lord.
What is the fate of MFA 713 of 22, madam?
It's still pending, my lords. Yes, please, my lords. And notice has been served in that appeal also, and they've entered appearance, my lords.
So long affidavit is filed without. What is the breach?
My lord,
To take second.
Contract.
After remarriage.
my lord, the allegation is that I have,
It's a entry mode.
Para 9 year mistake. To the contacted second marriage before the past date is training.
My lord, hearing a short accommodation may kindly be granted.
Hearing, no more hearing, para 9, last sentence, no, please. Before interim order ಗಿಂತ ಮೊದಲೇನೆ I have taken second wife ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ.
No, my lords.
You
May
work it out
kindly
with
be
the
noted.
appeal ಮಾಡ್ಕೊಡಿ.
Yes, yes, here he says that the statement of the accused in statement of objections at para 9 is that the accused number 1 has contracted the second marriage before the passing of the restraint order dated 3/8 to 2023.
Yes.
But my lords may kindly see that even before, even after filing of the MFA, that is appeal, and before passing of the interim order also, the appellant had approached the jurisdictional police and had lodged a complaint stating that he might contract the second marriage. At that point of time, he said no, my lords. And subsequently also, I have produced the documents also, my lords. Subsequently, after passing of the interim orders, when the appellant approached the jurisdictional police, in his statement, he has stated a different date, my lords, but now they admit that they had knowledge of the interim orders, my lords. And he, just to he is suppressing the fact that he had knowledge of the interim orders. And just to overcome that effect, he has made this submission in the statement of objections, my lords.
You are Miss Chandrakala.
Please, my lords.
And what is your good name?
Maheshwari, my lord,
Maheshwar.
for Madhukar Vishnu.
For Madhukar, heard learned advocate Miss Chandrakala ji for the complainant and learned advocate Miss
Maheshwari, for Madhukar,
Maheshwari.
Maheshwari.
For learned advocate Mr. Learned advocate Miss Maheshwari, for learned advocate Mr. Madhukar M. Deshpande for the accused. Full stop. Learned advocate the respondent, learned advocate respondent accused files
Statement of
the
objection.
counter affidavit which is taken on record.
Lord, he himself states that in his statement of objections that
While learned advocate, the respondent would submit inter alia from the averments in the counter affidavit that the contracting of second marriage by the accused number 1 was
Before this one.
much before passing of the restraint order dated 3/8/23, without going into said aspect and adjudicating anything on that score, the court notices that the order brought under contempt is purely an interim order. What it provides is that that pending consideration of IA number 1 of 2022, the respondent is restrained from entering into any contract of marriage or remarrying. Full stop. The main proceedings of appeal are pending before the family court.
No,
No,
he
Lord,
appealed
before
before
this
this
honorable
honorable
This
court.
In
before
MFA.
this court.
My lords, one submission with your honor's kind
For
permission.
this, 1 second, this court, full stop. It goes without saying that the order being interim in nature, it could not be said to be settling the rights of the parties finally. Full stop. No contempt would be entertained against the order which is interim in nature. Accordingly, contempt proceedings are not entertained, they are dismissed.
Milord,
Parties are at liberty to work out their rights further before the learned single judge in the parent proceedings.
Milords, one submissions with your lordship's kind permission, Milord. Milords, I had made the temple authorities as A2, wherein after the appellant came to know that the accused number 1 has contacted second marriage after the passing of the interim orders, the A2 also has confirmed that accused number 1 has contacted second marriage not before prior to the passing of the inter orders, but subsequently, that is on 19/7/2023, my lords. That is subsequent to the passing of the interim orders, only accused number 1 has contacted second marriage. That is the reason why I made A2 as party, because they have the footage wherein in the temple, in their temple only accused number 1 has contacted second marriage, my lords.
ಈ dictation ತಾವು ಕೇಳಿದ್ರ interim application ಮೇಲೆ no contempt will be entertained is the
That is the point.
See, please work it out in appeal.
My lord, the accused number 1 is present before the court today.
Contempt application is dismissed, accordingly dismissed.
Much obliged.
31.
In this matter, I am filing compliance affidavit. Therefore, the complainant, they have just served in the court. But my lords, they also say in our submission, my lords, there is no compliance. 65 pages of compliance affidavit is served in the court now. But please see the affidavit.
Time.
My lords, because they, in their affidavit, they say, I have passed an order, but I have given part payment. That is not compliance. There is an order of the government. But the affidavit says, I have passed an order, but I have given a part payment. The learned single judge's order is, if you come to the conclusion that they are entitled for payment, you have to release the payment plus interest.
So what they are doing now?
He says, I have passed, the deputy conservator says, I have passed an order that they are entitled to payment. But conservator of forest, on his instruction, I released part payment.
Part payment.
Part payment, and the calculation what they give, my lords, is contrary to their own auction bills. Lords, we will file our objections to this, my lords. At para 5, my lords, in their affidavit, they say that. Of their affidavit, page 4, para 5.
So what is supposed to be total payment?
Lords, it was 1,88 lakhs as per their auction bills, which they have given us. Now, my lords, what they do is, they are entitled for 10% that we are not disputing. Now, my lords, they have released some 28 lakhs or something. And he says, I am releasing part payment, where the single judge says, release the amount plus interest. It's auctioned by them, they have the bills.
How much due for you, sir?
My lords, out of 1,88 lakhs was our claim. In that 10%, they are entitled for deduction towards their surcharges, my lords. Now, instead of that, they come out with a calculation that some 30 lakhs is the part payment made. May I make a sir? What is relevant is, my lord, annexure R1, in which, my lord, there is a clear direction to make the payment by the government order. We are bound by the single judge's order, my lords. The order of the single judge is to consider their representation and make the payment. Lord, to that effect, my lord, we have passed an order. Make part payment. And no doubt, there was a part payment made, my lord. In the due course, my lord, the rest of, since there is an order of the government for making payment. Annexure R1, page number 33. Before the learned single judge is that specific directions are issued.
Interest, along with interest, they have to release.
So paragraph 11 of the order of learned single judge.
That is one part, my lord. There were two writ petitions. My lord, there are 5 pieces of land, my lords. 3 pieces are one writ petition, another 2 pieces are another writ petition. In that, my lords, if they kindly come to, my lords, the preamble at page 16 of the 16, my lords. This payment, what is released, running page 16 in the contempt, that's internal page 4, in WP number
They are
4205.
concerned with 42054.
Please, my lords, in that, please see Rome clause 3, my lords.
18011.
Yes. 180,11,600. That was their own bill which they had released to us. That's the auction bills, which they sold our timber. Now they've come out with in annexure R1, they have come out with some 83 lakhs, my lords. In that 180, they are entitled for 10%. We have no dispute. It come to about 160 and odd, plus interest. As per the learned single judge's order. At page 28, the learned single judge has ordered, my lords, that with the applicable interest, they should make the payment. If I am entitled.
So Mr. Mahendra, it is only in respect of 42053.
That, my lords, the amount what they are showing in this annexure R1 is.
Sir,
only-
your reservation or contention related to that petition only.
Only one, my lords.
As far as this 42, it appears, subject to what you say, 42054 of 15 is concerned.
There is an issue, my lords, 42054, we are entitled for amount.
That is what learned single said, that they are entitled to the amount.
Lord, to
As
that
prayed
effect, Lord, annexure R2 determination is the amount, net amount payable to the landowner is 73 lakhs 26,000 after deduction of 10%. Last page, Lord, page number 64
Page
of the
number,
counter.
page number
64
60.
of the counter.
So bill ಕೂಡ 428 ಅದರಲ್ಲೇ ಇರೋದಲ್ವಾ?
After all calculations, Lord.
73 lakhs.
Yes, 73 lakh 26,000. There are 2 orders passed, Lord. One is R1 and R.
In any case, the part payment is not acceptable.
Please.
Whatever the amount payable according to you, even if we don't go into it, how can you say that we'll pay in part only? You are improving upon the court's order, your officer.
No, I do admit, Lord, that's not justified. We'll pay in due course.
So
The
whatever
amount-
amount you think payable to them, you pay it in total,
Please.
Lords, in
When
fact,
dispute remains, we don't know whether we can be going.
lords, that we'll also produce the bills. It's their own bill before the single judge which they have issued is for 188. Today he brings it down to some 80. That's their own bills, my lords. I can't create it. They have auctioned it.
Sale of
Timber.
There is a counter.
74, 75, 60.
Counter.
Lords,
in I, yes.
28
Wow, acha.
would be a second unnumbered para therein
Modification.
with the applicable interest they have to pay us. The issue is, my lords, it's like this. The bills are there, whether I'm entitled for payment or not. If I'm entitled for the entire payment as per their own bills of 188 with interest.
Or they are entitled, you release it within. So let them release these 74 lakhs remaining. 45 lakhs now they have to release another.
From
45 lakhs.
188, he brings it down to 83, my lords, that can't be a subject matter which he can even adjudicate.
No, no, that is not quantified.
Of course, the bills are there, which was in,
We cannot
Quantified.
adjudicate.
no,
in the
your lordships,
contempt.
no,
But
the
now
scope.
according to their own document says 74 lakhs,
Yes,
75.
my lords, that's why, no, their own document.
Now they have paid 30 lakhs to you, remaining let
My lords,
45 lakhs. be paid.
I'll only say this, my lords. Before the learned single judge, what the bills we have produced, that's their own document. Auction documents I can't create, which showed
But
188.
There is no determination about
Lords,
the
then he-
amount to be paid, my lord.
I will finish, then my learned friend can say.
Please.
The learned single judge never gave them an option that they can determine the amount. It was only whether I am entitled to that right or not. Amount was already determined. I'll place those bills, which is the forest department's auction bills. My timber is sold to somebody, you have recovered 188. That was already on record.
Then we have to go through the procedure of how
Yes.
much you are entitlement, how much tax.
It is
how
only
much-
that the single judge has
In
crystal.
their
My lords,
order,
I'll only make
compartments
this.
of their
My lords, your lordship, give them time, but Arjun, I'll place that.
taxes, something like.
No, all that I am not disputing. I am lords, tax, all those I will not even dispute. Tax, 10% deduction, that's, my lords, we have considered that position. The only determination was whether I am entitled to the amount or not. Now, what is the amount they quantify is what the problem arises. Every time I'll have to come again, my lords.
For
If they-
what price it has been sold is clearly tabulated in page number 43. my lord.
That's the issue. We will show that he has given it. We will also show our bills, their own bills.
From 43, the details of the timber sold are as below.
Only the payment.
Both they have to sit and if there is any difference, they have to challenge.
My lords, your lordship may just see this. I will place my bills. My lords, it's their own bills. I can't, my lords, we can't be driven to like this because the single judge never gave them an option of quantifying the
My lord,
amount.
they are expanding the scope of this contempt.
Definitely
my
not,
lord,
my
because
lords, with great respect. If
There is
if
a
the
clear
learned single,
order passed
So
by
you
the
are
government.
entitled 1.8 crore in the order of the.
my lords, that's exactly what the learned single
It
judge
is there.
says. Please see the order, my lords. My lord, please come to the operative portion. The amount of 188 was never disputed by them before the learned single judge.
So
The
this
dispute,
contempt is related to both the writ petitions.
both, my lords. That's why so far as one survey number, they say, my lords, it's an unredeemed land. I will not get into it. I will have to challenge that endorsement. One, they say, two survey numbers, they say these are redeemed lands, so we are entitled for the amount. If I am entitled for the amount, I am entitled for the entire amount. Today, my lords, they can't rework. That's the judgment of the learned single judge. Please see at page 28, when representation filed by petitioner is for release of amount realized on sale of timber. It would be needless to add, in case findings are in favor of petitioners, they would be obliged to release the amount with applicable interest.
The last may kindly peruse page number 27, prayer.
Please.
Prayer also.
Prayer in the,
That's
I mean,
the
order.
order.
Order, I'm sorry. Page number 26 and 27.
Yes.
C is relevant. Respondent shall also determine determine the date, year of alienation of barley land and age of the trees at the time of such consideration. It has been considered and time of reconsideration shall be 4 months. Page number 27.
27, ನಿಮ್ಮ object statement of objection.
In the contempt petition.
No, you said that
Your
part
order,
payment is
orders.
released. Where is that? It is in compliance affidavit?
47.
No, you said that part 30 lakhs is released. Part, where is that everment?
That is not para 5.
In compliance affidavit?
Yes.
Clarified.
Yes, there are, it is.
Chief Conservator of Forest is directed to make part payment only. We will direct them.
Time may be granted.
Lord, with the interest they have to pay. There is no interest also. That's the direction. With interest. We
We are
can't
not-
escape these things, my lords.
We are not closing, Mr.
Your lordship may not close it, please.
But
My lord,
they,
that's what I'm
but
saying.
whatever the
So that
amount
I
is
can also
balance-
place my, please.
Not closing.
Then, my lords, I have no issue.
Not
If you're not lodged, no.
You
Then
please say-
Present contempt application came to be filed, seeking compliance of the directions. These directions passed by on a single judge. In order dated 30th/5/23. Read with order dated 14/6/23. In writ petition and in IA number 2 of 23. It would be relevant to notice the directions. Full stop. While disposing of the writ petition number 42053 of 15 and 42054 of 15. The court passed the following directions. Court paragraph 25, which is on page 26 and 27. Thereafter, order dated, supplementary order dated. Thereafter, supplementary order dated 14/6/23 was passed by the court in IA 2 of 23, in which it was directed that the representation of the petitioner for release of the amount realized upon sale of timber would be released
in 2 weeks.
in case the findings are in favor of the petitioners. Full stop. In response to the notice paragraph issued by this court, comma, the Deputy Conservator of Forest, appearing through learned government advocate Mr. Mahendra, S. Mahendra, has filed compliance affidavit. In the said affidavit, compliance affidavit dated, is dated 6th March 24, full stop. In the said affidavit, it is stated that the competent authorities have considered the directions. An official memorandum dated 10/1/24 has been issued releasing the amount. It is claimed that thereby the directions are complied with. In paragraph 5, the government's figure that the order came to be issued to pay to the petitioner the part payment of rupees 30 lakhs. Petitioner complainant. The order paragraph pursuant to which the order pursuant to which the aforesaid part payment agreed to be is proposed to be released is also on record. It indicates that total amount payable to the complainant is rupees 74,75,625 after adjusting the amount towards deduction of 10% supervision fee, maintenance expenses, tax, etc. Learned senior advocate. Paragraph. Learned senior Mr. Anindra. Disputes the total amount shown payable to the complainant as above. Be as it may. Paragraph. What the court could immediately notice is that while admitted while the respondents have admitted the amount of rupees 74,75,625 as above to be paid to the complainant, comma, the authority has, comma, for the reasons best known to it, directed the payment of rupees 30 lakh only out of the said total amount, which is towards part payment. Full stop. The court is of the clear view that this amounts to improving upon and overreaching directions of the court as far as the admitted amount is concerned. Paragraph. At this stage, learned government advocate fairly stated. Or shall we direct? Or we direct? We direct? Yes. All. In that view, it is directed that the respondent, competent authority respondent shall release the balance of the amount to make total payment of rupees 74,75,622 towards the sale of timber, comma, to the complainant, which shall be done within 3 weeks from today. Full stop.
4 weeks.
4 weeks from today. Full stop.
Lords, we will file our reply, your lordship opposes, because, my lords, their own bill says 188. Now, either he has missed.
Simple memo of calculation.
That's what, my lords, I'll exchange also with them in advance.
Learned senior advocate disputes the total agreed to be paid by the respondent.
And also interest part.
That even further amount is payable, comma, without expressing anything on that aspect, comma, presently we post the contempt postings after 6 weeks.
The interest part also is left out. Anyway, I'll file, my lords, we'll exchange a memo.
What remains is calculation now.
And the interest, my lord, the interest they will.
Where is that interest? There is never in the order.
It
Nor
is
in-
there, it is there, my lords, with applicable interest.
I am interest letters.
In that page 20. Page 28, my lords,
That I did not see.
at page 28. Along with applicable interest is there.
In the IEM.
We post the proceedings after, on which date? Reopening of the? Reopening. So on 15th May, more particularly in
Just
view,
before we
more
close it.
particularly when learned senior counsel drew attention of the court that in order dated 14/6/23, it is observed that the amount shall be payable with applicable interest. So now this is a indication to you.
Yes,
That you might have to pay the
I
interest.
understand. Obliged.
For the accused lordships, we have filed the complaint affidavit, we have filed. And the translation has to be done. Regarding annexures, translation copy has to be done, a week time may be accommodated, by that time I will translation.
Complaints, are you accepting the complaints? Sir?
They were directed to pass an order within 15 days from the impugned order. They are yet to pass any order till date. They have issued final notice and they're saying that itself has to be considered as an order in the affidavit.
No, my lord.
After the notice, the order is specified in page number 13 of the petition, my lords. After issuance of notice, they were supposed to pass an order within 15 days. That has not been done. Even as per the affidavit, it's not been done.
Basically, my lord, one by name Vijay Ashok Kumar has filed a writ petition against this accused and the complainant, saying that complainant has encroached the western side of the drainage without license, she has constructed the building. After conclusion, the learned single bench has passed.
So
an
notice
order.
is received.
What?
Notice is received.
Notice is received, I have replied.
Or-
Order has
or-
to be passed.
Order is not passed.
Order is not.
Order has passed from my lordship, sir. What orders we have stated that?
They point the notice itself as the order.
Where is your order? Show the annexure, Parvila, even if it is in Kannada. show.
Kannada, I will get you. Annexure. Are three, my lordships. I may be
Three, say,
permitted.
show, final notice.
This is the
Final notice, but in last para, I may be permitted to read out.
No question of reading, it is only a final notice. Where is
Final
the
notice.
order?
My lordships, what we have stated, as per section 197, if you are ready to remove the encroachment, we are ready to regularize the work construction. That is what we have intimated to.
Sir,
in final notice.
indicated to him.
Yes, my lordships, we have to remove the encroachment, then only we will regularize our illegal construction by imposing twice the revenue upon.
Then you pass order on this.
Please, my lordships.
Then pass order. Senate counsel for the accused, submit that the accused number one alva.
One is
will
all
pass-
accused.
Pass
All
orders
accused.
on the notice
And
and submit
And-
further complaint.
one submission, my lordships. My lordships, writ petition was filed by one person against this accused and the complainant. The writ petition was came to be allowed, saying that I may be permitted to operative portion of the order, saying that in page number 13 of their petition is hereby allowed partly. Respondent number one is directed to issue necessary notice to respondent number two within 15 days as per section 64 of the Panchayat Raj Act. And copy of this order specify the excess construction and violation which are required to be rectified by respondent number two. If any, respondent number two shall reply to the same within 15 days. She has not replied. And from the date of receipt of such notice, respondent number one shall pass an order thereupon within 15 days. This is the speaking order passed by the single bench, your lordship, sir, where it has to be questioned by the petitioner. Because petitioner is aggrieved by the encroachment made by the complainant. The complainant has filed the,
direction is
respondent
only
has
to the
filed the
respondent.
complaint.
Just comply what is the
Yes,
order
ma'am.
that is passed and bring the order on the final order.
Please, your lordship.
Any dates, my lords? Since
Yeah,
15 days, it's already been 7 months.
2 weeks. After
Weeks.
2 weeks.
2 weeks.
Grateful.
Accused in this case. Can you take him up by 2 weeks, my lord? See, I need to file a reply, my lord, in this case, detailed reply, my lord. The last section I filed wakalat, my lordship.
Lord, here is accused is a habitual contemptor. This second round of contempt proceedings, my lord, there is a direction to pay me the 17B wages. My lord.
In fact, we have challenged the annexure C, my lord, that came to be rejected in the last occasion before the single judge, my lord. Being aggrieved with the annexure C, my lord, we are filing a writ appeal also during course of the delay, my lord. Therefore, may can be taken up to 2 weeks, my lord, to file my objection also.
Filing the writ appeal.
Please, my lords.
May I make this submission. It's not this order of
That annexure C, my lord.
Page 20. Payment.
So you are filing writ
Please, writ appeal.
against which order?
Against annexure C, my lord. Annexure C is came to be, I have challenged annexure C, my lord, that
for modification of entry model, that is annexure C, my lord. Based on modification application is came to be rejected on
So this
19
4325 is what?
that is the main writ petition, my lord, which is a challenge.
Challenging some labor code
17 BHC I have filed, my
filed
lord.
by the employer,
Pardon, my lord.
filed by the employer.
Please, my lord. I have filed the petition.
What petition you are going to file?
Pardon, my lord.
Cross petition you are going to file?
I didn't.
You want to file which writ petition?
Writ appeal, my lord.
Appeal.
Please, my lord. Because
Modification of
annexure C, please. Lord, may that writ appeal. Both the matter may be taken up heard along with contempt petition. My most respected submission is, my lord, this is the second round of contempt petition. Earlier, my lord, he volunteered to reinstate me, but he did not. Then I initiated contempt proceedings wherein non-bailable warrant was issued. Then he produced an order of reinstatement in the open court. I was allowed to work only for 5 days. Then he issued a memo. Then, my lord, I filed this application seeking modification of the order of reinstatement into that of payment of 17B. Now, the learned single judge has been kind enough, as per annexure C, to modify the order of reinstatement into that of payment of 17B. Now, my lord, it is almost now 8 to 9 months. Lord, so till today, we are ready to reinstate the appellant, my lord, but they are making some false allegation. Please, see, my lord, para 18.
You
my
have to
lord,
comply para number 20 of this order.
please.
You comply.
Para 18, my lord, the learned single judge has clearly, my lord, noticed the earlier proceedings. I need to file, please, because we are ready to reinstate
Within 2 weeks, you finish whatever you want to finish.
please.
Whatever
you
modification. Otherwise, you have to comply with this order, 17B.
Please, my lord.
As a matter of fact, this, your liability to comply with this direction is independent of your filing anything.
Just short accommodation may be provided, my lord. In the meantime, I can file.
Deposit. That is what I'm saying. What is the amount payable? This is exactly in our mind what.
No, it is,
brother said.
now it is about 12 to 13 lakhs, my lord, because it has to
How
be
much?
12 to 13 lakhs.
13 lakhs.
My last on wages was about 35,000 as on the date of termination.
What is the date of termination?
Termination, my lord, in the year 2019.
19.
2019.
Then 13
17, ma'am. 10, 12, 2017, ma'am. 2017.
So what amount you are going to deposit?
Need to get instruction, ma'am. Need to get instruction, ma'am.
Your remedy of whatever kind you are pursuing, you may pursue is independent of your.
Hello, may make one submission, my lord. My lord, we have after filing a petition, we have voluntarily undertaking to reinstate the appellant, my lord. Till today, they are not coming and work the job, my lord. And also we have given separate cabin also to work with the premises, my lord. May I based on some false allegations, my lord. May I invite my lord's kind attention to paragraph page
Also, she worked
37, my lord,
after
page
termination,
37,
what?
Paragraph 18.
She worked for only 2 days, my lord. For that day, for 2 days, we have paid salary, my lord. Remaining days, she has not appeared, my
We are
lord.
concerned with 17B order. Salary paid, not paid, not.
You have
Whatever
to file
due
the,
in respect of 17B direction, you have to pay. So you just tell us what amount you will be depositing out of 13 lakhs, you are saying.
I can pass over the matter. I can pass over the matter. I need to get instruction, my lord.
Pass over.
Please, my lord.
We'll take
Take an
instruction.
instruction and come and make.
The
Your-
amount, quantum of.
Somebody is there and we have a petitioner present.
Today is unable to appear. Today is unable to appear, my lord, before the son.
Who has to pay?
Accused, my lord. Accused, my lord.
No, we don't want accused here. You deposit the amount. You call him and over
Please,
this one and get the clarification.
Please, that's-
How much you are going to deposit? Only for that submission, pass over.
Naturally.
please.
Petitioner, subsequent to filing of the petition, my lord, we have issued an endorsement with liberty to challenge that endorsement 1612. The petition may be closed.
You will liberty to challenge the endorsement.
Endorsement.
And counsel for the complainant submit that the accused has issued the endorsement.
Accused, my lord.
Seeks permission to challenge the liberty to challenge the endorsement. With liberty to, with such liberty, complaint closed.
Please, my lord.
Grateful.
They are filed objection just now, I am received just now, my lord. I have to go through, they are not, as per that, they are not compliant. The simple order, my lord. The complainants are the daily wages working in the complainant.
1 minute, sir. Let the senior counsel say, make a submission, what complaints they have made.
The compliance is made, my lord, we are filing the objection. May seek a 2 days time for this reason, my lord. I find the translation made is very I'm in an awkward situation. The translation is very
Next Wednesday,
please.
next Wednesday.
In fact, it's ready and we had also served a copy, but
Just now they asked for that.
ಆಯ್ತು ನೋಡಿ ನೀವು ನೋಡ್ಕೊಂಬನ್ನಿ. Then let senior counsel submit that 1 week time to be. There's in statement of objection, some corrections has to be kept. 13(3).
Lord, in this case, my lord, compliance has been done, my lord. Compliance has been done. Lord, the only thing is, my lord, I could not produce a translated copy, my lord. Yesterday night only I received this endorsement. I may permit, I served a copy. I just furnished a English translation.
So representation and annexure AD.
ಹೌದು, ಅಲ್ಲ, ಅಲ್ಲಿ ಕೊಡ್ತೀನಿ.
accepted, Anak.
1-3, my lord.
Accepted.
Yes, my lord. Promotion has been given.
Go through this, reply, my lord.
It has been communicated on second to the complainant also. He has received,
Madam, what remains?
No, my lords, I will seek instructions, my lords.
That's in Kannada, madam. Sorry, my lord, I could not produce immediately. It's in Kannada. 1-3, my lord, order.
You have given promotion.
Yes, my lord. Only thing is to consider the representation, that was the direction. Promotion has been given.
Motion on 21/2/20.
I recommended to you promotion. We are closing, madam. No point in keeping pen. You are given promotion. Yes, madam. Received, my lord.
ಕೊಟ್ಟಿದಾರಲ್ಲ promotion and with effect from 24/2/24. FDA ಮಾಡಿದೆ.
ಹೌದು.
Learned a single judge in order dated 6th April 23 passed in the writ petition. Directed the respondent university to consider the case of the petitioner as per his representation dated 22/2/23. The grievance of the petitioner was about non-granting of promotion. Full stop. Today, the compliance affidavit is filed, in which, along with the amendments made in paragraph 5, that the case of the petitioner has been recommended to give for promotion to the post of first division assistant from order dated so and so, so and so.
Order dated 1/3/20.
1/3/24 is also annexed, evidencing the recommendation to give the promotion. In that view, the order is, directions are complied with. Contempt proceedings are closed.
Any grievance, my lord, in respect of the promotion, retrospective grievance is there, my lord. That liberty may be to work out his remedy, my lord.
What liberty? You are
Here,
given.
my lord, he is entitled for retrospective promotion, my lord. He is entitled for retrospective promotion. They are given.
That you can-
That liberty may be open.
Nobody prevents you to challenge anything.
Obliged.
This is number 37, Mr. KBS Manian.
And this is against an interim order passed in this petition. Therefore, accused number 4, on the last occasion, my lord, the client had not appeared. So on that ground, bailable warrant was issued. So we have made an application for recalling of that bailable warrant because there was a mistake in noting down the date on the part of the party. Accused number 4.
I appeared for accused number 3 in the matter.
And accused number 4 is not a party in the writ petition.
My lord, both these affidavits which are filed on behalf of 3 and 4, I mean, I really have no objection for the withdrawal of the warrant. But even for the sake of recalling an order, both affidavits are identical of two different accused. It cannot be. Either one of them is lying on affidavit.
Lord, this is against an
Kindly see
interim
both
order.
the affidavits. Para 3, it cannot be that both made the same inadvertent error by noting the computer. I mean, some sanctity, I mean, I have no objection. I think we can, I'll leave it at that.
Not be too technical.
No, I will not. I just pointed that to the court.
And A4,
My lord,
Lord,
that can be recalled. I have no objection for the warrant to be recalled.
A4 is not even a party in the.
First of warrant is to secure them before. the
Absolutely.
court.
I agree with the court.
Respect of the order.
Absolutely. I bow down to the
Respect
court.
The order, they are.
I have
before
no objection, my lord. The warrants may be recalled.
Accused number 4 is not.
For
even a
whatever
party-
reason they've said in the affidavits.
Is not even a party in the writ petition.
No, that we will.
And the interim order has been granted against some of the parties. Recall.
No, we will argue on merits. I mean, let my friend file his objections. We have serious issues in this matter, my lord.
So we'll say pursuant to order dated 1/3/24, the accused number 2.
Accused number 4.
3 and 4 are
3 and 4
present.
minutes. I appear for
in the
accused
court
number 3 in the
Who are identified by learned advocate for the respondent. By the learned advocates appearing for them. In view of the presence secured, comma. The proceedings shall stand over to 2/4/24 as
Grateful.
originally fixed. Full stop. The warrant is discharged. We are permitted to file our objection.
Sir, 2 you file counter. This 2/24, both the applications, allowed. Already we have. Okay.
Number 38. Passion and JD.
Hearing for complaint. Is not
filed complaints affidavit.
That complaints affidavit, my lord, is not a complaint. I'll file my rejoinder, my lord, since there is a clear direction by this court. And they have made an undertaking before the learned single judge. And my lord, now they have created a title dispute where my vendor has not disputed.
Your last may kindly.
It is, my
peruse
lord.
The order. Direction is to conduct Kodi and Durasti in a manner known to law.
Allah, kindly, my lords, why I have approached the learned single judge. Kindly, my lords, page 16. They have appeared before the single judge, my lord. And they have made an undertaking. Now they are saying, my lord, there is no required to be Podi. Podi has been conducted much earlier in the 2010 and my property itself is in dispute. I am in possession, I am in cultivation. After lapse of 30 years, my lord, now they are dispute, 38 years.
Having.
And my lord, the Podi has been done to my subsequent purchasers. Where, my lord, I am the first.
There was to conduct Podi and Durasti.
They are not even conducted my properties Podi, my lord. They submitted it only in saying that
May kindly.
Podi has
peruse
completed in year
para 5
2010.
and 6 of
You are
the
the petitioner.
Yes, my lord.
So Podi is conducted in respect of the petitioner or not?
No.
the body conducted in respect of the subsequent purchasers of the land. They have sold the land. The last may kindly peruse para 5 and 6. I have.
If you already sold the land, then very.
No, my lord, I have not sold. Let them, my lord, show one document. I have approached the court, my lord. I am the owner.
Then file review application. File review application, get it clarified.
Kindly, my lord, one submission, my lord. Kindly for a moment, but some paragraph in the complaint. Which is not my case, my lord, which is contended in this court, contended in the affidavit.
Your limitation, jurisdiction and contempt is very limited.
No, my lord.
You are aware of it.
Yes, my lord.
We can't go into here and there in all of these
Kindly,
questions.
my actual submission is that the learned single judge order is not complied, my lords, in their affidavit.
Our
says-
area of jurisdiction is the specific direction given. Nor we can improve upon, we can read less, can't read more.
Kindly,
So
my
all
lord.
these questions you want to agitate, you go before learned
Kindly, my
single
lord,
judge.
I'm not placing any disputed questions, my lord. The affidavit in which it is
Not
filed.
disputed, any other question.
No, my lord. Which is, my lord, what exactly the undertaking before the learned single judge to complete the PODI. That has not been done, my lord. What exactly now they are showing that the PODI of 2010.
But then you seek the specific direction.
These things, my lord, are very much available, my lord, before the learned single judge. After listening to these things, my lord, the learned single judge and the officer was
So
present.
the The land was sold by them at the time of,
Wife of the
no,
original
when the,
grantee.
when the order was passed, the land was already sold.
Yes,
Then you misled
No,
the.
my lord. If my lord, that is my lord, let them file an affidavit. I'll file counter affidavit, my lord. I am not sold.
Then you
Let them show us, my lord, the one document, any
The-
sale deed.
If the land was already sold.
No, my lord.
At the time of passing of the order of learned single judge,
No, my lord.
you misled the learned single.
No, definitely, my lord. I am ready to face the contempt, my lord, for that misleading, my lord. Let them show, my lord, the one document. I have misled the learned single judge,
Now,
or my land is sold.
Now make a choice.
Kindly, my lord.
Make a choice. What do you want? You want to order or you want to go before learned single?
Kindly, my lord, my submission, I will go before learned
You
single
have
judge.
considered.
But I have not sold, my lord. I have not sold.
By
Then
virtue
go
of
before
this
learned single.
compliance, you place all this material before the honorable single judge and seek a clarification and also further orders.
Yes, my lord, that may be clear.
No, because the order is
I will go
only
for
40 and
I will go
jurisdiction.
before
we
a
did-
single judge.
You are withdrawing.
Kindly, my lord, that, my lord, for clarification,
You
will
withdraw
not-
right and after thereafter you come.
that reserving.
Come
your-
again if you want, you can come. But these are we are closing. Learned government advocates states by filing, you file something?
Yes.
Memo.
I'll
Compliance
file
affidavit.
affidavit, my lord.
Compliance affidavit. By filing compliance affidavit that the directions regarding conduct of 4D and Durasti is complied with and the 4D and Durasti has been
Already has been done.
already conducted in respect of the land in question. Paragraph. In that view, the contempt proceedings are closed. Paragraph. However, learned advocate Mr.
Kashna Chedi.
has certain reservations about the body and Durasti conducted. He submitted that the applicant may be permitted to approach learned single judge for the clarification which the applicant may perceive in the subject matter. So without expressing any opinion on the said aspect, it is open to the applicant complainant to approach learned single judge in respect of the order dated. We need not say in this contempt process. Why should we say? Says certain reservations about the compliance, certain reservations, full stop. The remedies in law are not, the applicant is, the complaint is not precluded from taking any remedy in law, as may be available in law.
Number 39, Mr. Sampath.
It's the pollution control board's order, my lord, the closing the factory. I was called in question, my lord, the main ground is that, my lord, the annexure B is the order of closure order, my lord, passed on the petitioner industry. I was saying that, my lord, certain complaints has not been done. Lord, the main, my lord, the contention is, my lord, they have inspected the property. They pointed out, my lord, there are certain defects. The ground is that, my lord, they have not issued any notice saying that these are the complaints, you have to do it. My lord, directly passed an order of closure. Now, my lord, the petitioner, my lord, these complaints from the residents has been, my lord, being received. But he said, my lord, he wants to shift the factory itself, my lord, to some other industrial places. But he's raised for some time, my lord, so that it would be, the petitioner industry would be shifted, my lord. But this complaint, my lord, this was the industry established long back, my lord, in the 2014, the residential areas have come up. Now, my lord, residents have started giving complaints, my lord, because of such situation, my lord, the petitioner company wants to shift to some other place, my lord, to put an end for all this, my lord. The main grievance is, my lord, annexure page number 17. My lord, the rule 20 capital A of the air pollution rules, my lord, says, my lord, before passing the closure order, my lord, the 15 days notice has to be given, saying that, my lord, these are the problems in your factory. If you not comply, my lord, then they will going to pass an order. My lord, that without passing that, my lord, notice and without giving me or without pointing out me, these are the defects, you have to comply. Straight away, my lord, the closure order has been passed.
That's in this matter, that's annexure 8, page number 13, maybe you look at. It is a proceeding of a personal hearing. It is much more than giving a opportunity of show cause merits. The petitioner has participated in this particular hearing. We have pointed out defects, subsequent to which the order of closure has been passed. Now, it is a case where in 2022, a closure order was passed. They approached this court, and for want of jurisdiction, that order was set aside. That order also is placed on record at page number 28. For want of jurisdiction, the order was set aside. Annexure E, page 28. The operative portion is at page number 31 and 32, my lords. 32, paragraph number 10. Subsequent to which, my lords, my lords may turn to annexure B, my lords, annexure B, page number 17. The reference portion, my lords.
Page?
Page 17, my lords,
Annexure B.
which is being called in question. That's the order stated 16th of March 2022, my lords, subsequent to which, my lords may see from serial number 10. Page number 17, annexure B. From serial number 10 onwards, my lords.
6.
Multiple inspections, not one, my lords, not two, more than 4 inspections have been conducted. Based on the inspection, my lords, they've been called for personal hearing, and that personal hearing, my lords, is what is at annexure A. Annexure A is that, my lords are with me on page number 13, my lords, annexure A, the proceedings of personal hearing. I request my lords to annexure A, page 13. My lords, the personal hearing was conducted on 17th Feb 2023, my lords. And my lords may look at the people who have represented, my lords, from the bottom. Representative from the industry. The petitioner has attended to the proceedings. After which, my lords, the closure order is issued on 26th April 2023. My lords, after 3 months. And they're saying that, my lords, we did not know anything about inspection. We were not given opportunity. And second, my lords, at page number 16, my lords, the finding of the personal hearing, my lords. Page number 16. Unnumbered paragraph number 3, my lords. The presiding officer heard both officers of the board, complainants and industries, seriously noting that though the industry is established and operating during 2002 and have obtained CFE, that's consent for establishment, only during 2007 and also carrying out said activity without obtaining consent of the board till date by violating the provisions of Section 25 of the Water Act and 21 of the Air Act, and without providing adequate air pollution control measures, even after having given several directions from Regional Office Dharwad, which shows the careless and negligent attitude of the industry authority towards complying with the CFE conditions and complying with the provisions of the Water Act. That's all they had was only a CFE, that is consent for establishment, and they were operating methods without even a CFO.
step taken.
I just pursued. Please, my lord, may just pursued, my lord,
After
the,
that, my lords. After that, my lords,
my lord, the rule 20A, my lord, they say, no doubt, my lord, I have not disputed that there's personal hearing is not been given. The personal area is given, but they have not indicated what are the problems we have to rectify. My lord, they may just pursue the rules, my lord, which says the rule capital A under which they have invoked. My lord, they have to specify, my lord, what are the defects, and they have to give me a time to comply that, my lord. Without giving, my lord, I never said, my lord, I will not comply. The personal hearing also they have noted, my lord, they said there are several directions has been issued. My lord, they also placed on record, my lord, the statement of objection. They not even produce any direction notice, my lord, direction document. Look, rule capital 20A of the air prevention rules, my lord, may just pursue your lordship to that rule, my lord. Air prevention control. 20 capital
in
A.
fact, in the
Rule.
personal hearing, it was also recommended that his consent for
rule.
operation, what he had applied for, should not be processed, which means, my lords, he does not have a consent for operation even today.
Capital A.
No, 17th February and subsequently this,
That's 17th.
26th April.
Yes, my lords.
So what is this 27th February notice?
17th February is the personal hearing, my lords. As my
Personal.
lords had seen it, page number 28.
And
it's
the
very-
26th February, April
It's a
is
closure
order.
direction.
Order.
So that's what happens is once we give them an opportunity, my
Order.
lords, after 3 months, we close it. My lords, even in 3 months, if they're not able to comply with it.
Then there is
No, my lord, may just pursue lordship, my lord, the rule 20A capital, my lord, rule 20 capital may just kindly be noted. Lord, it says, my lord, Lord, under 20, section 31 capital A, my lord, the issue, they has the power to issue out closer direction. My lord, these are the rules, my lord, they need to do it, my lord, the
28,
20 capital A, my lord.
20 capital A.
Please, my lord, 20 capital A directions, my lords. May just read it, my lord. Any direction under section 31 capital A shall be in the writing. The number 2, the direction shall specify the nature of action to be taken.
Subsection 3 is complied with.
My lord, the person, my lord, the officer or any other to whom any direction sought to be issued shall be served with a copy of proposed direction and shall be given an opportunity of not less than 15 days from the date of service of notice
all
to
done.
file with an officer.
It was done, my lords. What happened is we have issued an NPD back in the year 2015, my lords. My lords, I have to make a statement, my lords, that we have also been backsided, my lords, after issuing NPD, which is a part of his own pleadings. 2019, we again go ahead, my lords, and refuse the consent. Now, my lords, we have gone ahead following the procedure. My lords, dehouse all the submissions, my lords. Even today, if my lords were even to allow this particular document to be taken as or treated as a show cause notice, he cannot conduct any activities for a simple reason that he does not have a CFO. Well, it's on base of an interim order, he's running the industry.
No, my lord, the cancellation of the CFO is also called in question. My lord, the annexure A is, my lord, the cancellation of the consent. My lord, the both, my lord, annexure A and B both are. No, my lord, the petitioner.
Proceedings of personal hearing. I don't know which annexure my friend is referring
The
to.
annexure you are referring to.
No, my lord, the petitioner company, my lord, he said, my lord, if it's within 6 months, my lord, he wants to shift, he's already made arrangement to shift it some other industry.
It not work, that's the difference.
No, my lord, there are more than, my lord, the 100 people are depending on this, my lord, the status quo order. My lord, within 6 months, my lord, we'll shift to we'll file an undertaking before this honorable court, my lord, within 6 months. It will shift it to some other place, my lord, within 6 months. The status quo order which been continuing, my lord, they also not. There is an.
Can't pass such order.
My lord, lord, due to the COVID things, my lord, they also, they had some financial.
4 years
My lord,
of lapse.
COVID it's
no, my
everything
lord,
finished.
it is, my lord, there are some orders, my lord.
You are remembering COVID.
No, my lord, there was some problem, my lord, because the elder member of the family has also been expert, my lord, they had some problems. No, my lord, within sooner, my lord, they will shift it, but because there are some orders, my lord, until that orders be completed, my lord, because they, to shift the industry, my lord, they are even not the competition, my lord, the laborers are depending on them. They will all be on the street, my lord. Just breathing time, at least, my lord, 4 months, my lord, we'll file an affidavit before this honorable court that within 4 months, we'll exclude, my lord. From the 4th month, my lord, we'll.
The rule 20 capital is complied
Yes, ma'am.
before passing the closure order.
My lords, it's a part of, my lords, may look at,
Personal hearing complaints.
And observation made by the inspection team is at page number 15, my lord, it is clearly stated,
50,
1-5.
1. That is.
Drawing observation.
Yes. Very.
Well, even the annexure, yeah.
1-5, my lord. Details of noise levels and the following observations made during inspection on 10/11/2022 as follows. And the same is reflected in the closure order also, page number 19. Even after 3 months, blood, this is not rectified.
No, my lord, this only is observation. My lord, they never given, my lord, they also
This
stated
was
in the.
done in presence of the
Being
complainant.
an observation, does it not?
We'll say that you
indication of-
approach the authority for, we are dismissing the appeal.
No, my lord, my just,
For whatever further extension, you decide for yours. As a court of law, we are not granting any.
no, my lord, it is the process, my lord, the annexure.
Direction, if we consider or don't consider, my lords, if we don't consider, it come as a contempt. If we consider, my lords, another writ petition.
No, my lord, even, my lord, my submission is, my lord, there's only observation, my lord, they observe, they also stated, my lord, there is no buffer zone, my lord, I cannot be made blamed that there is no buffer zone. My lord, there is no direction, even this is annexure is only proceedings, my lord, there is no direction that these are. Direction, it's only, my lord, it's only proceedings. My lord, they not even direct, these are the problems you rectified. They not, they, my lord, the direction may kindly see
Statement
to
of
recommend the
objection.
closure, my lord, they not stated.
Statement of objection, my lords, at page number 27, an inspection report in the presence of the petitioner owner.
My lord, there is an inspection, I have not denied.
Sir, when you are given a personal hearing, you can't raise such.
Please, my lord, there is a personal hearing, but they have not yet pointed what.
Why are they invited for you for tea?
No, my lord, they never pointed, my lord, they asked, my lord, even I also made some complaints, my lord, I also produced, my lord, annexure, F and E, my lord, that I also made certain changes, my lord, when they brought it. Annexure F, my lord, page number 34, I have stated, my lord,
You better stick on to your undertaking.
my lord, I shall, my lord, within, my lord, at least, my lord, 3 to 4 months, my lord, please, my lord, because immediately if it is closed down. Because since my petitioner says, my lord, they already wants to shift the, my lord, since 4 months, my lord, let them, please, my lord, because if immediately closed down, my lord, many, not only petition, my lord, there are many laborers, my lord, they will also be prejudiced. But there is interim order of status quo, they are not challenged. First,
I find an objection.
just for minimum, my lord, 3 to 4 months, my lord, I just.
He cannot continue the
Activity
industry
itself.
without CF, my lord. That is
Lord,
the.
We'll reserve liberty for you to give undertaking with them, then you decide whatever.
Yes.
We are dismissing this petition.
Even, my lord, annexure, they have not issued direction, my lord, only personal hearing, my own submission.
Yes, you mean the reset with this.
Yes.
That much will observe, you can. You will approach for
Some
shifting purpose, whatever you will.
and my lord, so
Get him for shifting first. Because according to them, there are 100 workers.
Yes, ma'am.
You pollution control will do all those things you do for him.
I will tell you.
Number 40, Mr. D. Basurajappa.
For petitioner. My lord, this PL is filed,
R11 is dead, sir.
my lord, I need,
So R2 has refused the notice, held sufficient.
my lord, I
R11 is dead.
need 4 weeks time to ascertain and
Learned
bring the
counsel
LRs
for
on
the
record of.
petitioner seeks time to ascertain the legal representatives of R11.
I think
4 weeks.
it can be issued, removal of encroachment.
25-4.
Yeah,
Number 41,
wholesale encroachment. Wherever.
Sharath Gowda.
Memo of retirement.
41.
Other level notice ಹಾಕಿದಾರ ನೋಡಿ, please check whether he has annexed the notice and. Oh, yeah, they can be signature of the petition.
So notice will go.
Signature of the petitioner number 1 is taken along.
Filed in the nature of public interest, not
Accept this.
private interest.
Yeah. Full stop. Along with the memo of retirement, the council on record has taken the signature of the petitioner number 1. Full stop. Permission accorded to Shri N. Sharath Koda, permanent council, for the petitioners to retire from the case. Full stop. No representation on behalf of the petitioners. Hence, writ petition is dismissed for non-prosecution.
Number 42.
The appellants, there are two submissions minutes as
For
far
the
as
respondent number 1 and 2.
service of copy is concerned to respond number 1 and 2. I was served before matter came up for hearing itself, but since he had filed the caveat that office of
Accept.
note may be overruled.
Respondent
And
two is finished.
second submission is with regard to response number 3 and 4. There's a
Chairman,
change
you
in
are
the-
appearing for R1 not to sir?
Please, please.
We'll delete the note number 2.
File the caveat.
note number 2 minutes.
And R3 and 4?
I take steps for R3 and 4 since there is a change in the address minutes and I may seek your lordship's indulgence.
Ken Manohar Learned Council is appearing for R1 and R2 as a caveator.
Please.
Office note 2 shall be deleted.
A copy has been served.
M.N. Kumar Learned Central Government Advocate seeks time to take steps in respect of R3 and R.
After that may be permitted to serve by hand respond number 4 since he is available here only.
This authority.
No, he is individual, is a secretary of the
Summons also permitted.
permitted to listen to, interim order to be continued.
Interim order.
Because here this approach, only 2 petitioners here, the respondent number 1 and 2. The ICDR is taken over by the central government. Entire asset
Or
and
the
liability.
salary of
Yes, only.
arbitration,
Yes,
international
ma'am. Yes,
arbitration.
ma'am.
Lordship, that's why exactly it was the case.
Except 2 laborer.
Now it is taken over by the. They are not paying the salary of the staff. ICDR. Then international-
That's only undertaking is taken over without affecting the character of the society minutes.
Passing the pieces of our shell.
And page number 182 is the affidavit filed by the secretary. They categorically contend that they have been working under them, society, under the very society itself. Unless and until they work for the government cannot make any payments. There was no relief sought against the government with regard to the payment also minutes in that.
So now it is merged with it. Now the staff arm filed this petition that they are required to be paid.
Page number 182 may be seen minutes.
Now we has to, now they are requesting let the central government pay. Central government pay, they are not.
Page number 182 may be seen minutes. This is the affidavit filed.
Anyhow, you do complete it, sir. You are Mr. Sundaresh, here Sundaresh, you serve. on.
Yes, I will surround.
Okay, fine.
Page number 182, para 10 minutes. They have clearly admitted no relief sought against the Union of India to make the payment. It was sought against the respondent number 4 only.
Let the after
Obliged.
appearance of Mr. Sundaresh, we will take a call, sir.
Available.
Date may be.
2 weeks. Kodtar.
8th April.
You are Mr. Sundar.
No,
No,
madam.
he's
I'm for the respondent number 1 and 2.
Or 1 and
Available.
secretary is Mr. Sundaresh, is the R.
Date.
8th April.
Match up.
43, Mr. Subramanya Bhatt.
This matter will not be complied with the order.
For the complainant.
Yes, madam, complied.
Yes, your lordship.
Full stop. Learned GS submitted that the order of
Complaint submitted.
direction has been complied with. Counsel for the complainant is not disputing this.
I'm filing complaints affidavit.
Complaints report is placed on record. Contempt clause.
Number 44.
I pay for the complaint. The direction by the learned single judge, my lord, has not been complied with. This is in the nature of,
Department of Industries and Training.
grant of salary, my lord, to the petitioner. Since the order of grant, my lord, has already been confirmed with the learned single judge.
They are not even paying the present salary, my lord. I'm awaiting instructions.
Then we will direct the appearance of the accused person. Full stop. Learned GA submit that he is awaiting the instructions from the accused. Full stop. The next date of hearing, then full stop. Complaints is not reported. Hence, ಯಾರ್ ಬೇಕು ಹೇಳಿ ನಿಮ್ಗೆ, which one we required a physical if to give the effect of that order. Commissioner A2. A2. Accused number 2 is directed to appear physically in the next date of hearing. What do you want date? Parle, physical.
8th of April. Number 45. RP Somshetwaya.
For a petition in this case, please, not. Yes. In the instant case, please, minutes. There is a report of the commissioner appointed by the court, please, minutes, saying that there are sufficient number of students in the school, please, minutes, for prosecuting the study. The horse of the same, please, minutes.
Asking for permission to write the SSLC exam.
Unless the students approach the single judge, please, minutes.
Institutions had initiated proceedings. The institutions had made students to appear before the single judge. And that petition was dismissed on 24th January 2024. With a cost of 10,000 rupees each. And the state council on record.
They brought the students before the court.
This is the order, please, minutes passed by the learned single judge. This is the order passed by the learned single judge, imposing cost of 10,000 rupees on the students who had sought permission to attend the examination.
The remedy of the students as addressed it already. So last time we have raised the question, students.
Please,
are
minutes,
before-
whether the students have not appeared.
They are already come and gone.
They have failed.
Students in,
Court remains now.
well, students in fact had appeared, plus had approached this honorable court.
Good person.
The institution will have to protect the interest of the students, please, minutes. The students in fact
It is
approached this
going
honorable
against
court.
the institution.
Plus, not filing of an appeal by the student please minutes is difficult. They all come from a rural area. They're all poor please minutes. They could not afford filing of an appeal. That is one of the reasons please.
The remedy required for the students, let the government take care of their interests.
Plus 11th examination,
Regarding you and the government, you work it out.
plus 11th examinations will commence please minutes. If they permit the student to take the examination,
the purpose is served. I'll not be pursuing the writ petition itself.
But the problem is you are asking the direction to the government to recognize your school and then allow them to write the exam.
Plus, from a different school itself, they can do it, please, not necessarily from this particular school.
Now their submission is that let the students be permitted to write the SSLC examination through any other institution. If we record the statement of the government, if you are satisfied, you will close the writ petition now on.
So that could be done, please. Eighth and ninth. Eighth and ninth students.
There.
Board exam has been set aside for the 8th and 9th standard. Yesterday, the order was passed for the learning single.
Set aside.
No board exam for the 8th and 9th
Eighth and ninth,
standard.
we are in Karnataka, I'm not sure about free.
But then nothing remains.
Then we'll conduct the examination.
Tenth
The
standard.
school itself can conduct the examination. As far as the tenth standard,
No need for any.
as far as the
explanation.
tenth standard is concerned, please, permission may be
Say it should
considered
not be a public
by the government
examination.
to conduct the examination through some other institution, please. At least for this year. By next year, please, we will be in a position to take the recognition. Well, recognition has been, recognition has been withdrawn only day before yesterday, not earlier to that, please, I got the order of the government, wherein the recognition has been withdrawn only day before yesterday, after filing of the writ petition, please,
The permission was withdrawn just day before yesterday. Let them make a statement. You have the copy of it, sir? Copy there.
Please.
That de-recognition.
And this has not been the same.
Permitted to read it, please, I did not bring the copy, I am permitted to read. In view of the above facts and circumstances, failure of the petition school to show minimum admission
Again, 22 to 24. And 3.
Am I permitted to read during the pendency of this appeal, my lord, this order was forwarded, my lord. During the pendency after filing the appeal, my lord, they have passed the order withdrawing the recognition. Only of the above facts and circumstances, failure of petitioner school to show minimum admission and attendance of pupils in compliance with the required standards and failure to show improvement despite being provided opportunity in the year 2000 as well as in the 2018 would not inspire the school to provide further opportunity, make efforts for the improving the strength of the admission and students pupils. In fact, the petitioner would be bound by the affidavit undertaking so on.
So reading the order dated 22 to 24, sir.
Please,
There.
This is after filing the.
Writ
this
appeal.
appeal is filed on 21 to 2024. After the.
You assign these things in separate proceedings. Now they will record the undertaking of the learned government advocate that
Yes.
your students' interest will be protected insofar as they writing the examination.
That will be sufficient, please.
SSLC
That observation.
coming
With
exam.
that observation, the appeal itself could be disposed of, please.
Madam. ಹೇಳಿ.
Schools have been brought into this school.
No, no.
One of the officer is present, making after submission. And one of only to project that there are students in this school. Along
Then who are the which school, from which school they have brought here? They should have records, no?
Two inspection
Ah.
report by the department itself.
There are two inspection reports. Well, why the other school students seek permission from this school? When they are already.
They are, according to them, you are swapping school itself.
You're already accommodated in other school.
Plus, those are the students who were prosecuting studies in this particular school. Their attendance register, their admission register, and their photographs are also produced by the commissioner. Attendance registers are produced.
The commissioner's report, my lord, whether he has brought to the notice of the court of the report, the evidence that were there. And that is that page 267.
They dispute the building, they dispute everything, please, the playground, the name board, everything is disputed.
Since 1898.
Since 1898, I have been.
1980.
1980, I have been running the school.
They have to provide, if there are any students are there in this institution, they let them provide, wherever, from wherever, let them.
Wherever,
Madam,
wherever they are studying, you can take examination. That is the position obtained.
Now, the position is that now with the recognition and the review cancel allowed. If any application is to another school.
They are-
First, there are no, so the question of shifting doesn't arise, but still they say that there are students. So if they say there are students, then the officers are present.
madam,
to
there are
recommend.
30 students who have already come before us. So where are they studying then?
For other schools.
Then you should produce the records to show that they are all the students of some other school. Because these are 30 students have come before the court,
This is the exam.
25th.
claiming that they are the students of their school. Please give.
You just,
They have taken the hall tickets for the 10th standard SSLC. 19th.
They have forcibly taken us.
Admission ticket. Date of exam.
Well, as my instructions are that they have been shifted, please, forcibly, please. Forcibly, they have taken the
now you are
children
again.
to
adding
some
new
other school.
dimension. Now you are adding new dimension
That
and
is the
you are
instruction given by my.
throwing your own skeletons in the cupboard.
Some students are here.
Sir,
Now
we
we
are
are not
interested in the paramount interest of these minor children. who
But
are
that is
about to take
important, please.
Examination.
The
Now they are
students,
producing the admission.
the
ticket
students'
issued
interest
by-
is paramount, please.
So their interest is now taken care of.
ಆಯ್ತಲ್ಲ ಮತ್ತೆ.
Now they have issued the admission ticket, government PU college, Ardnalli, KR Nagara Taluk.
I leave it at this stage, please. All the 30 students.
Record
they
of
accommodate.
statement and close. ಹೇಳಿ.
All the 30.
ಏನು ಇದು?
All the 30 students.
Art Sri Ravi B. Naik, learned senior counsel and government advocate. Full stop. Learned government advocate is made available. The copy of the order passed by the honorable single judge in petition 2687 of 2023, dated 24/1/2024, wherein 30 of the petitioners who are claiming to be the students of the petitioner institution has came to be dismissed as the institution itself has filed the writ petition. Full stop. Learned GA also made available the copy of the admission tickets issued to these 30 students through government PU college, Ardnalli, KR Nagara Taluk. Is it correct, madam?
Yes.
Full stop. On perusal of same is in conformity with the records. Full stop. In the alternate remedy is made available to these students to write their coming SSLC examination. The purpose of writ survive
Please, Raj.
is become infringed.
It becomes infringement.
Accordingly, this
Liberty to
petition
challenge
is.
the order. Liberty to challenge the order.
But that we are only interested in 10th standard. Sir,
Please. Go. The derecognition order may be permitted
that
to
you
be
are
challenged.
permitted, that's independent of this. That's all 46.
Two applications are filed. One is continuation of delay of 11 days, my lord.
R4 is dead.
R4 has passed away after the disposal of the writ petition and prior to filing of this writ
Under
appeal.
which provision you have filed these applications? Order 22 rule fall for, you file application under 146.
I'll make the necessary correction.
You are already implemented them.
They were not impleaded in the lower court, the single bench before,
Sir, in
because
this
they, respondent number 4 passed away after the disposal of the writ petition
Ah.
and before filing of this writ appeal. In the interim period, he has passed away.
Then 22 rule 146. You make an application under 146.
I'll make that. Kindly, a date may be fixed, my lord, I request.
Sure. Full stop.
And 11 days delay, kindly.
Yes, yes. The learned counsel for the appellant submitted that the fourth respondent was died after the disposal of the writ petition and before filing of the writ appeal. Stop. Seek permission to make necessary application under section 146 of CPC instead of order 20. Permitted. For needful, GA takes notice to R1 to R3. Madam, now there are R4, 5 to 8,
Our individual parties, I will take notice, my lord.
notice to R5 to 8.
April.
My lord, IA number 1 for continuation of delay, may kindly be.
No, without appearance, could we condone delay? Huh? Yes.
Here for the complainant, my lord.
For the accused in this case, my lord. So the accused has been abroad, my lord. So we are unable to contact through telephonic, my lord. Accused in abroad, my lord. We are unable to contact through telephone, my lord. So can you take it up next week so that I can get a proper instruction?
Thirteen lakhs, sir.
Your lordship, it comes around 12,60,000, my lord.
He's in abroad.
Please, my lord.
Now his client is in abroad, he wants instruction.
Out of country.
Deposit some token
Lord, lordship.
to show your bona fide.
I have to get instruction before.
For that, no, you are representing,
Pardon, my lord.
you are the lawyer, you can
Please.
tell on it clear. What amount?
A week's accommodation provided, since he is unable to contact me, that is the unavoidable circumstance.
It's a industry, na, industry is private
Industry,
limited.
please,
Na,
ma'am,
somebody
please.
is responsible person is here who is taking care of the administration.
Taking care, and also we are given separate cabin for whatever their position, my lord. So between the workers, my lord, there made some quarrels. So some internal.
All
issues.
different, only complaints,
Please.
we are only talking about the
I need
complaints.
1 week, my lord, and date may be fixed, my lord, so that I can proper instruction may be provided without fail, my lord.
Counsel for the accused submit that his client is abroad. He needs to complete the instruction within a week.
Please.
My lord, date may kindly be fixed, my lord.
15th March.
Very well, very grateful.
Please.
Number 47, G.R. Mohan.
Appear for the petitioner. This matter pertains to the deforestation of Kodagu district, wherein from 2018 to 20, there were landslides earlier, and several loss of death and other things are happened. Now the statement of objection, last occasion on 8th February, the court granted time for them to file. Now they have given the copy of the statement of objection, Your Lordship.
File that.
Yes.
Not the address of the she is a resident of Bangalore. But as a grievance in respect of for the book.
Do you file the response?
I find the
It's
response. My learned sir has any grievance for that because his grievance with regard to deforestation has also been met.
Para 4 onwards, they say what the steps they are going to take. Para 4 of the. So one,
We are
one, sub-
satisfied with the affidavit.
one submission I want to make in this regard.
Reasonably elaborated.
Now,
During the
at paragraph 9, Your Lordship,
9.
last paragraph 9, page 5, Your Lordship. It is submitted that after the enactment of Karnataka Tree Conservation Act 76, the tree cutting is restricted to maximum extent so and so, the code is except so and so. The forest department has been instructed to permit cutting of trees measuring 2.85 cubic and 5 tons firewood to the farmers as per chapter 5 of the Karnataka Tree for the development of coffee crop, Your Lordship. This is what I am point. For development of coffee crop in the tenure of redeemed sago and sago dry, the trees permitted for felling is as per the government circular number so and so soon after felling. Now this circular which is in contravention of the Forest Conservation Act 1980. It's a central act that will prevail. So only that aspect, let them examine that, and other things are all it can be Forest Act, Your Lordship, Forest Conservation Act 1980. Restriction on de-reservation of forest, Your Lordship. There the central act says that the cultivation of tea, coffee and other things, all for that purpose they can't fell the trees. That is what it says, the Forest Conservation.
A person who's a resident of Bangalore, and not is taking up a cause of Kodugu, and the residents of Kodugu don't have any grievance.
Only that aspect. May I read that provision, Your Lordship, that Forest Act, Forest Conservation Act 1980. Your Lordship. Sorry, one paragraph. Only that circular is contrary to the Conservation Act, Central Act. That's all. The other things are all for the farmers to take out for their firewood and other things. There is no problem because even the Forest Act, original act itself provides.
But the
Forest
government circular
Conservation
is
Act.
under challenge. The government circular is not.
Yes,
under
other
challenge.
things are all substantially they have done it. Only that let them examine that. That's all. While in future, at least not now, at least in future. May I read one just for a moment, Your Lordship. Permit me to Forest Conservation Act for a moment. Because in the Kodagu district, most of the lands are all private lands, Your Lordship. So they take permission from the concerned forest department and then they can go ahead with it. Okay. May I read, Your Lordship, for a moment?
You are G.R. Mohan.
Yes, Your Lordship.
So read petition number 11240 of 2020. Our learned Advocate Mr. G.R. Mohan for the petitioner and assistant government.
And the additional government.
Additional government. So and so. To the respondent state and its authorities. Claiming to be selectivist. The petitioner has filed present public interest litigation.
That prayer was confined as per 3rd July 23 order, only to
Don't
defund.
enter.
Other prayers have been.
Please don't.
Yes.
Enter. The cause sought to be espoused is in respect of deforestation. According to the petitioner, resulted into landslides in Mandakiri, Kurg. Principal prayer, paragraph. The petition was to direct the respondents to consider the representation of the petitioner and further to constitute a court-monitored special investigation team to conduct a study in order to prevent the unauthorized sand mining activities or any other constructions like homestays and resorts. The subject matter in the prayer paragraph of this public interest petition was considered by coordinating bench in order dated 3/7/23. It was specifically observed that the prayer made in the petition was too vague to be countenanced. Full stop. This court entirely agrees with the view expressed in the said order. It could be noticed paragraph from the said order that the court entertained the present petition for the limited purpose, observing that since the aspect of deforestation was raised in the petition, the government was required to file statement of objections. Today, when came up for consideration, learned additional government leader stated that today you are filed the statement of objections. Dated 6/3/24. The same is taken on record. Correct. The deponent has in detail delved into the aspect of deforestation about which certain grievances were sought to be voiced by the public interest petitioner. Full stop. In paragraph 4 of the objections, it is elaborated thus. In paragraph 4, vacated portion. Starts with it is submitted up to construction of houses. The next paragraph. The details and the figures of the compensation distributed during the past years are also given in the affidavit. Then court further vetted in the same paragraph. Further it is submitted, not further, during the loss in land split. It is stated, paragraph, that the landslide and floods take place during the years, during the unfortunate years, come as a natural calamity. It results due to abnormal heavy rainfall. It was stated that the massive landslide did not take place on account of deforestation. It is stated that the district administration has taken all precautionary measures while issuing the conversion orders, licenses for resorts and homestays. It is further stated, paragraph, that the existing roads in the entire Kodagu district are properly maintained and improved periodically. Any land acquisition or deforestation or pouring on hillocks is not permitted. It is stated that the trees which naturally fall on the roads are required to be cut and removed to ensure the smooth flow of traffic. Paragraph about the topography and the climatic aspects of Kodagu district, the respondent has stated thus in paragraph 7. Quote paragraph 7. It starts with the Kodagu district as a thickly wooded grandeur adopted by the forest department. Paragraph. It is claimed that the forest department has taken all the protective measures for eco-restoration, afforestation, reforestation and conservation of works in different ways. And that afforestation of 3064 hectares has been completed in last 7 years. The Mandikiri division under various afforestation schemes. Stated that as per the India State Report, 1970, 79.80% of the geographical area is under forest cover. Paragraph. While learned advocate for the petitioner was unable to dispute the facts and figures narrated by the respondent as above, he referred to the averments in paragraph 9 of the statement of objection, which mentions about circular dated 4/1/14. Which contemplates that the forest department has been instructed to permit cutting of trees measuring 2.850 cubic meters and 5 tons firewood to the farmers as per chapter Roman capital 8 into bracket 3 of the Karnataka Tree Conservation Act 1976. For the development of coffee crop in the tenure of redeemed sagu and sagu dry, the felling of trees is permitted as per the said circular. It was sought to be submitted paragraph by learned advocate for the public interest petitioner that this circular runs against the provision of law, full stop. While there is nothing to indicate the substantiation of the said submission, there is no challenge to the said circular. In any view, this court does not find any substance in the grievance raised by the petitioner in relation to the said circular, which permits the felling of trees for selective necessary purpose, full stop. It is to be noted, paragraph, that is the resident of Bengaluru and seeks to raise thoughts about the residents of the Kurg and Mandikeri area, full stop. It is difficult to visualize that the petitioner, who is the resident of Bangalore, has the first-hand information and experience about what he is complaining of. Paragraph. In any view, having regard to the statement of objections filed by the respondent pursuant to the order dated 3/7/23 of this court, the court is satisfied that no further proceedings are required to be taken out in this public interest litigation, full stop. With the above observations, the petition is dismissed.
Number 48, P. Ramesh.
Sorry, my lords, last occasion, I have taken time today, my lords, because in this matter, my lord, senior has been instructed. My lords, due to his personal inconvenience, my lords, he could not appear before this court personally. My lords, could it be taken up on next Wednesday, my lords?
Then after 2 weeks.
Lords, Wednesday, my lords, any date may be fixed, my lords, but.
My lord, this matter is going on.
Wednesday thereafter, 20th March.
Yes, my lords.
Sir, also senior.
My lords.
Yes, my lords. My lords,
Lord,
due to
he-
his
Patil is online.
But he could have informed us, my lord.
Their counsel has come on.
Yes.
For the third respondent, he is appearing, my lords.
My lords, my request, my lords, is that if the date could be fixed and no further adjournments to be taken.
Lords, I will not seek any further adjournment, my lord.
ಇಲ್ಲ ಆಯ್ತು ಡೇಟ್ ಕೊಡ್ತಾ ಇದೀವಿ ಸರ್.
So Mr. Counsel, 20th March would suit you?
Very well, my lords.
Yes, 20th.
Much of it.
Grateful to your lordships.
Yes.
28th, my lords.
28. Please, much of it.
Number 49, S. Vital Shetty.
My lords, in this case, this appellant is a retired employee of Astral Vijaya Bank. He suffered a dismissal from service. In this, on his termination of service, he was not paid the gratuity amount as applicable for the Vijaya Bank employees gratuity fund rules and regulation, which is a better terms, which is entitled to receive under section 4(5) of the Payment of Gratuity Act. Payment of Gratuity Act has not made any differentiation between the persons who are terminated by way of dismissal or anything or superannuated as far as payment of gratuity is concerned.
Notice heard on its senior counsel, Mr. Sohan.
Yes, Vital Shetty, notice.
Notice 6.
Text notice to R2 and R3, madam. Controlling authority under payment of gratuity act, ನಿಮ್ಗೆ ಬರುತ್ತೆ. Assistant Labor Commissioner, R2 and R3. GA text notice to R1.
19th April. December 50, the Sagar BB.
Business counsel. Lord, the appellant was appointed as a clerk cum data entry operator on contract basis, my lord, by a resolution dated 22nd July 2011. Lord, 22nd, Lord, 2011. Lord, the appointment
So nothing wrong.
yes, there is a.
What is
Lord-
wrong with the order?
No. There is a margin delay of, my lord, 9 days. On merits, my lord, I have got good case. My lord, as I submitted, my lord, the appellant was appointed as a clerk cum data entry operator on contract basis, my lord, by resolution dated 22, my lord, July 2011. Lord, annexure A, my lord, page 27 may kindly be seen for a minute. The typed copy of page annexure A, my lord, page 65.
What is it?
In the bottom, yes, right, in the bottom, it is when the said matter was discussed in the meeting, Devraj of D. Basavanalli Tanda is appointed as a computer operator on contract basis as a computer assistant and for the year 2011. The appointment of the petitioner was approved by the Jilla Panchayat as per Annexure B, my lord, page 82. My lord, the typed copy is on page 84. Page 84. Subject,
giving approval to the appointment of the post of data entry operator of Sri Devraj, BMK, Biddi Gram Panchayat, Kadur Taluk. Lord, the approval given by the Jilla Panchayat is abruptly, Lord, cancelled as per Annexure C, Lord, page 92.
Today you are not in service.
Today, because I have been removed from the service.
Notice.
Yes, please.
Yeah, Judge, notice to R1, notice to R224.
Please.
19th April. Number 51 urgent, number 52.
For the petitioner's counsel. Lords, the order under challenge in the matter at 52, my lords, is an order by the NGT, National Green Tribunal, my lords, dated 25th of July, 2023.
Supreme Court.
I can.
Section 22 is clear, no, of the NGT Act.
If I can
Appeal
answer
to
the.
Supreme Court.
Let him finish, my lord.
Yes.
He will answer.
Yes, yes.
Let them finish, my lords.
Let him finish and let's all finish.
The same question before issuing notice, my lords, I had addressed that. Anyway, if your lordships can get the judgment which I had passed on, it is only after that, my lord's notice was issued. In the case of.
Yes.
My lords, Madhya Pradesh High Court Advocates Bar Association versus Union of India, reported in 2022 SEC Online 639. This was an Ilwa. One copy. I had addressed this issue. Anyway, my lords, I'll. This was the question which fell for consideration before the Honorable Supreme Court, my lords. While considering that issue, prior, my lords, I will take your lordships to from para 18 to 22 that is considered, but please come to para 12. My lords, where the learned Attorney General addressed.
Para 18.
Para 12, if your lordship kindly comes, my lords, and then I'll take your lordship to para 8. Para 12 is the statement of the learned Attorney Generals. Starts with the learned Attorney General. Next contends that the remedy before the High Court for a litigant under 226 and 227 continues to be available notwithstanding the enactment of the NGT Act and the provision for appeal to the Supreme Court under 22 of the NGT Act. It is specifically submitted by the learned AG that the High Court's power of judicial review remains unaffected by the NGT Act as it's a part of the basic structure of the Constitution as was declared in L. Chandrakumar versus Union of India. Thereafter, my lords, please come to para numbers 18, my lords, which your lordships would get internal page 6. about the issue-wise discussion whether NGT Act, it starts at para 19 onwards. At my lords, the running page should be internal page 6, my lords. Issue-wise discussion is mentioned there on left-hand side on top, my lords.
Paragraph,
My lords,
paragraph.
it is para 19, 18 and 19. My lords, I'm reading 2022 SCC online, 639 SC.
This is, they are given live law.
Lords, I had passed on SCC. I'll have a copy of the SCC.
19, insofar as the country.
Yes, I have given this.
How it starts?
Yes, yes.
Insofar as
Yes,
the.
please, my lords. That's the thing. Twenty-two, the lordships consider on Chandrakumar's case. 20, my lords, of course, the Attorney General's statement, para 20. And regarding the conceding of the legal position, that writ would lie.
Arguments now he's come. Now he'll come to that. So it's
And para 22. my lords. Para 22, they answer that in the negative. That is, my lords, that it does not house the jurisdiction of the High Court, 14 and 22. On this, my lords, that there is a window open. That's how, my lords, this writ was. That is how it was entertained, this writ petition. After answering on this issue, it was not that an ex parte order was granted on the first day. I had to convince, my lords, anyway, I'm just, your lordships can still decide on that, but prima facie, my lords, what I'm trying to say is that this issue not came up once, but there was a connected matter. It came up even then. There's one more third matter which is not listed. Even at that occasion, it came up. My lords, that's how this judgment was relied on by us. Anyway, my lords, that is on the maintainability. I'm only saying, my lords, the other larger issue is maintainability, and entertainability is a settled position. It's different. Any writ is maintainable, but not entertainable. That's the subtle difference, my lords, which has been laid down. On merits, I can take your lordships, my lords, to the orders.
So on the maintainability issue, my lords. That's my, Ranit Senior had pointed out paragraph 22, my lords, of the judgment.
And I may also point out, my learned friend had answered, addressed this issue before the other bench.
That's the question which fell from the bench was, is a writ maintainable? Even the senior agrees, my lords, that filing a writ petition, entertaining a writ petition are two different aspects. My lords, with regard to entertainment of this writ petition, that's the observations made at paragraph number 20.
You are saying that it is maintainable, but may not be.
It's not, yes, my lords,
So that much yes, sir.
it cannot be entertained for a simple reason that, my lords, at
So now
paragraph
let
number
us be clear about your stand. You are indirectly conceding that the,
No, that's,
in view of this judgment, it is
my
maintainable.
statement is not
It is
that.
maintainable but not entertainable.
That's my statement is that, that's owing to paragraph number 21, until and unless they fall under the three circumstances which the Supreme Court has told, Maharaj,
Let
it
us
is
see
neither, yes, Maharaj. At paragraph number 21, Maharaj,
21.
which my lords would find at internal page number 6. It can be further be noted that in terms of the above ratio and L. Chandra Kumar, the high courts have been entertaining petitions under Article 226 and 227 of the Constitution against the orders of NGT. While exercising such jurisdiction, the courts necessarily exercise due discretion on whether to entertain or reject the petition as per the test broadly laid down in Whirlpool Corporation versus Register of Trademark. And there, my lords, they call out two paragraphs of this.
Same judgment, alternative remedy, Whirlpool is.
Yes, my lords.
Yes.
In that, my lords, the second paragraph, my lords, that is paragraph number 15, which has been mentioned here. Under Article 226 of the Constitution, the High Court, having regard to the facts of the case, has a discretion to entertain or not to entertain a writ petition. But the High Court has imposed upon itself certain restriction, one of which is that if an effective and an efficacious remedy is available, the High Court would not normally exercise its jurisdiction. But the alternative remedy has been consistently held by this court not to operate as a bar in at least three contingencies, namely where the writ petition has been filed for enforcement of any fundamental rights, or where there has been a violation of principles of natural justice, or where the order of proceedings are wholly without jurisdiction or the virus of the act is challenged. That's based on these observations, that's paragraph 22 came to be answered. That's in this writ petition, that's what is being challenged is Annexure A. And that's the petitioner here is a party before NGT, has filed his objections to the petition, and he's contesting it. Now, that's having done all that, coming before this court under 226 would not arise. Irrespective of what is the.
They are already before the tribunal.
Yes, my lords, they are. My lords may turn to page number 62 for a moment.
Again, interim order.
It's an interim order. Against an interim order, they've come before this court. My lords may look at page number 62. They filed detailed statement of objections to the petition. Annexure C. Statement of objections, my lords, on page number 62, my lords. Statement of objections filed by respondent number 1415. My lords, the cost title, my lords would get at page number 43, the NGT cost title. That's the cost title of NGT is at page number 43, which shows that that's respondent number 14 is the petitioner hearing. That's the interim order is at page number, starts from page number 36, and the operative portion is at page number 39. That's our respective submission is that if the have to get any sort of remedy methods, this is not the forum methods, they may have to seek for modification of the order if they are affected by the order methods.
Which order?
The interim order. The interim order, what is being challenged before this court is at page number 36, Annexure A. A writ is not maintainable for the Annexure A methods. The matter is still pending before the NGT. And it's listed tomorrow minutes. It's the only.
For the interim order, whether you have been heard, sir,
My lords,
before passing this impugned,
I'll get into the merits. My learned friend wants, I thought only on the maintainability.
Your maintainability.
have
I'm
you
not
been
talking
heard
about
or
this.
before you
No,
expect-
I'm not hurt. Please see, my lords, that's what I want to point out. MOEF files a report on 20th. My lords, we are working the area from 2008. 20th July, and a report came to be filed by MOEF. 25th order is passed. And my lords, I also want to point out, it's not as simple as how NGT is being made out to. That's what we want to point out. After the interim orders granted by this court also, please see how NGT is taking upon itself. That's what happened. NGT passed this order on 25th July. On 3rd, my lords, your lordships, after hearing us, 3rd of October, my lords, your lordships stayed the NGT order, my lords. 3rd of October in this matter. Thereafter, I'll just point out, my lords, the order sheets, my lords, of NGT, when the matters comes before the NGT.
Before
Now,
entering
let
into the-
me complete.
Before entering into the merits, I would like to point out one paragraph in the judgment.
You would like to,
Point out one paragraph in the
from this judgment?
Yes.
Now, please see how NGT takes upon itself, my lord. The matter is listed on 30th October before the NGT. Well, I'll take on the merits of the first order, but please, what I want to point out is, please come to page 4. It's the order containing, my lords, order dated 30th of October 2023 by the NGT. At page 5, NGT takes note that this honorable court has granted a stay. The lordship gets it, my lords. Then, my lords, please come to para 9. NGT says, my lords, counsels to apprise the High Court about violations committed by us. All right, we'll take that. Then, my lords, the next order is on 22/11/2023 at page 7, your lordship should get. Please see page 8, my lords. That's on 22/11/2023. I know, order sheet of NGT, I'll give you. Then, my lords, it records stay is extended. Then again it says authorities to apprise the High Court in the matter and get an appropriate order from the High Court. In the meanwhile, what happens is, my lords, this honorable court, my lords, what NGT had directed the Pollution Control Board to take action and the MOF. MOF, based on NGT order, which was stayed by this court, passes an order suspending the environment clearance. I file a writ that is stayed by this honorable court on 14/12/2023. That is taken note on 29/1/2023. 2024, your lordship may kindly come to page 9 of that memo. That's the order dated 9. At page 10, it says, file a statement listing out the number of writ petitions filed by the project proponents and particulars about the orders under challenge. Your lordship gets it at 10. Then the matter is listed on 12/2/2024 before the NGT. Please see at page 12, what the NGT says. The High Court has stayed without any conditions. They have obtained the interim orders from the High Court. Oh, my lords, I will satisfy your lordships on the main first order. But, my lords, a forum whose order has been stayed, you don't follow that order. I have not, my lord, with great respect, in my experience, I have not come across where the trial court says, apprise the High Court about the stay granted. Or even the High Court, my lord, saying, apprise the Supreme Court about the orders which have been stayed. NGT is following it, saying, you go apprise the High Court.
So according to you, this statement in paragraph 9 makes the things maintainable?
No, I'm saying, my lords, so far as maintainability, my lords, now that's why, my lords, what I'm trying to make out is, please see, my lords, we are working
This observation tribunal cannot decide the.
I understand, but my lords, the problem is, please see, my lords, my lords, I'll just say, my lords, the petition before NGT was filed in 2021 by an organization which has not even prosecuting the matter before the NGT. Now, please see the prayers which they had made before NGT in their.
Even if the exceptions are carved out in this Madhya Pradesh judgment.
Yes.
They are same as one would.
That there is no.
While bypassing the alternative remedy.
Now, yes, my lords, if I am not even heard, then, my lords, I was a party to it, no doubt. I have said so in my statement, in my writ petition. It's not that I've said I'm not a party. I was a party. The statement of objections were on record. There was already a report.
And there is one more factor. You are aware that in 226, we normally don't entertain the interim orders.
My lords, I understand. I know the, my lords, I understand that.
There is still one more factor, section 22. The scope of appeal before the Supreme Court is same as section 100 of the CPC.
Let's.
So substantial question of.
Please, my lords, in this case, please.
They're traveling in a road which goes narrow.
Lords, but then the window is open, my lords. That's the window which we take. The window is open. Now, my lords, what I am trying to say is, lords, here is a petition which challenges something. Please see the main prayer and the interim prayer in the petition which was filed before NGT. I'll just point out few things, then I'll leave it to my lords, my lords. But what I am trying to say is, one report comes on 20th. We are not even given a chance to even comment on it. The observations made by NGT is wrong. I am not even heard. And entire mining and quarrying in the entire district is prohibited. That is not even the scope. That could have been the main prayer.
Which paragraph you are going to show now?
Not, the object of constitution of NGT itself is spelled out. Para 8 of live law judgment.
CC copy. Another copy. CC copy.
Explaining the purpose to constitute the specialized court to deal with environmental issues in monthly tapazone versus forward.
Para, sir, para 8.
SCC.
8 is different than what you are.
SCC, which you are, I think, live law you are reading.
Yes, live law.
11. Insofar as creation.
Back to up in the. We're talking about after NGT, no?
You are reading para 13.
Next page.
Backdrop of the National Green Tribunal.
Yes.
15, para 15.
Explain the purpose of
Purpose.
constitute, to constitute. the
Constitute the
specialized-
specialized court to deal with environmental issues in monthly and so on so. Justice as writing for 3 judges bench made the following pertinent observation on the status of NGT. The tribunal has been established under constitutional mandate provided in Schedule 7, List 1, Entry 13 of the Constitution of India to implement the decision taken at the United Nations Conference on Environment and Development. The tribunal is specialized judicial body for effective and expeditious disposal of cases relating to environmental protection and conservation of forest and other natural resources, including enforcement of any legal right relating to the environment. The right to healthy environment has been construed as a part of right to life under Article 21 by way of judicial pronouncements. Therefore, the tribunal has special jurisdiction to enforce for enforcement of environmental rights. Furthermore, the NGT is set up under constitutional mandate and so on and so on. In regard to the environment, and tribunal was conferred special jurisdiction for enforcement of environmental rights. It thus appears that the role of NGT was not simply adjudicatory, but also had equally vital role, which is preventive, ameliorative, or of the remedial category. The functional capacity of NGT was intended to leverage the wide power to do full justice in the field of environment. The NGT came into existence as sui generis institution established for enforcement of environmental rights emanating from Article 21. After NGT was set up, the Supreme Court pertinently directed the transfer of environmental cases pending before High Courts. Earlier, Lord, High Court used to deal with all this matter. Now, Lord, NGT is taken over. Therefore, Lord, this cannot be equated to the trial court because NGT tribunal is presided over by retired Honorable Judge of the High Court.
That is not the consideration.
My submission is that is why, Lord, the appeal is provided before the Honorable Apex under Section 22 of.
In principle, you are right, but not because somebody.
It is under the superintendence of the High Court.
Appreciate your contention in principle. No? Not- We'll continue. We have to rise because of.
Yes.
When
Continue. Well, its interim order is extended.
Yes.
Lordship's permission, my lord. Till number 47, your lordship has dismissed, dispose your lordship, may kindly record. Because they have, based on our petition, they had acted on that, Kodagu district. Serial.
All dismissed. are
Can be
disposed
disposed of instead of.
All disposed over dismissed.
Serial number 62.
In that, the hearing is concluded and my lords directed the parties to file their synopsis.
That reconstruction.
Services complete on all the parties.
There are non-compliance office objection, 3 objections.
On borrower,
Two
the
parties,
notice was
one
not
is
served in the writ petition. Then my lords felt that I should file a memo. Memo also is filed.
So service.
Serial number 55. Serial number 55, my
One
lord.
second, we are reserving the order,
Grateful.
provided service is complete.
Service on respondent number, the 14th respondent is not complete. I have filed a memo to delete him from the
Dispensation. of notice.
Yeah, the dispensation of all.
Serial number
For
60.
And my lords have recorded that on the last.
R14, R14.
Heard so and so, counsel, hearing counsel with assisted by so and so for the petitioners. And so and so for the petitioner and learned advocate who appears, give the appearance. At length, the learned advocacy party stated that they argued the appeal finally. They further stated that the pleadings are complete and no further are required to be added or supplemented. Reserved for judge.
My lord, serial number 61, my lord.
Filed a IF for direction.
Initially, you are dispensing with the party, which party? Respond number?
Which was
14.
14.
Fund number 14, I am deleting.
So deleting.
Giving a memo.
My lord, serial number
My lord.
68.
So at the beginning, so and so praise for deleting respondent 4, respondent 23, whatever.
Serial number 68, my
Said
lord.
respondent stands deleted from the area of respondents at the cost and consequence of the
My lord, serial number 61.
appellant.
68
Then the
final.
order of reserve, yes.
Lord,
Serial number 68 final hearing. Interim order can be extended.
My lord, serial number
Interim order,
61, my lord.
It will
Will be
be.
That may
extended.
be
71, your
please.
lordship.
My lord, 55, serial number 55, that annual increment, my lord. The serial number 55,
It will be
155.
Take a
My
date
lord,
will be.
serial number 61.
71, your lordship. I filed a IF for direction that IA may be put up because it's posted for final hearing earlier, last second. So by virtue of the direction, the petition itself can be disposed of. IA for direction regarding this
71.
last matter. Your Lordship.
71, madam. Don't,
My lord.
Mr. Chairman submit that and I find an IA for directions.
71.
IA ಏನು ಇದೆಯಲ್ಲ sir, there is an already IA 1 of 24.
Yes, your Lordship.
It is there.
That can be, because so that it can
71
be.
is on hearing on IA.
My lord, serial number 61.
PPP council is
My
also.
lord heard this matter and directed us to file written synopsis and written submission.
Repeat tomorrow, which is the matter, we not remember. Tomorrow.
Item
61. Regarding compassionate appointment. On behalf of university.
Married daughter.
Please. Divorce.
21 also, my lords. Your lordships wanted to hear 21 also. Along with
Let, madam.
21, which is
Hearing is
effective.
concluded,
No, they have to give further, post it for further.
post it for next.
Further hearing, it will come on further hearing along with the,
21.
contempt. Contempt number ಹೇಳಿ madam?
21, serial number 21.
21. 21 serial 21 and 61 shall go together. Club ಮಾಡಬೇಡಿ, ಅದೇ same date, give the same date.
My lords. Submission. Claimant is under great financial difficulty, his concurrent finding of.
Appear for the appellant in this case, my lord, I sought for the interim order extension. It may be posted on Monday only. I am ready for the arguments.
You want early date?
His concurrent finding.
You want early date?
Yes, sir.
We'll give.
I am MSME.
For 14th.
68.
Tomorrow, no, 14th.
14-3.
My lord, serial number.
Interim order, my lords, in that case, interim order. My same case, I am appellant for that.
Serial number 60, my lords, I have sought for some interim reliefs, there is some urgency
Date will be given.
for a date to be.
Will be given.
63, my lord.